Made.
Yes.
But back to mention item number 20. This was moved only on Thursday last week, my lord. And your lordship, if I recall correctly, dictated that this should be fixed on, my lord, October, my lord. It appears, my lord, wrongly. We have just taken steps on the respondent number 2 also.
Okay. Whether date was fixed? No.
That was fixed. Our understanding was that it was on 23rd of October, my lord.
Okay. So today.
And only last week it was moved, last Thursday.
Okay.
My Miss Ginny appeared, my lord, on last.
The Land Council for the petition submits that.
Wait.
Where is the order?
Order, it has been reflected, and obviously 9 must have been wrongly
9.
recorded.
It
Yes.
should have been actually 10.
Actually 10, man.
Yes.
We have just taken steps on the private response.
Okay.
Let's move on 17th, man.
Yes, it was 10.
Should have been.
Yeah. Okay. Some is that the prayer was made for listing this matter on October 24. However, due to graphical error, it has been listed today as pray for listing this matter on date required.
October. Yeah.
Okay. 24th October, the prayer. He has also obtained consent from the Land Council. He is also informed. So just a minute. Who is for the other side? Government.
Government.
Okay. The Land Education PP for the state has now including this is matter on 24/10/2025. Okay.
Interim order.
The interim order was will continue till the next day. Okay.
All right.
My Lordship, I beg to mention item number 24. Please adjourn this matter. Consent has been taken from the opposite council. And Your Lordship, can this after the vacation?
You are for the appellant.
No, respondent.
Comment.
Due to personal difficulties, the council could not appear before this court.
But then, see, this is a fixed matter. When it is a fixed matter, we have to see. And then after troubling, then you again take adjournment. It's very difficult. Miss
M. Jarang,
Land Council for the respondent with the consent of the Land Council, the appellant, pray for this matter
after vacation.
after vacation. The prayer is allowed. Please take matter after the ensuing vacation. Okay.
Much obliged.
Your Lordship, I beg to mention item number 22. I appearing on behalf of M. Doji.
May I please, Your Lordship?
Mr. M. Doji is not able to argue the matter. 22, Your Lordship. I am taking concern.
Okay. For appellant.
Yes.
What is your prayer?
The convening custom, Mr. M. Doji is due to some personal difficulties. Is not able to.
Okay. Who is for the have you informed?
Yes, came out. I am taking concern on other side.
Okay. You are Mr.
Sita Jo.
Land Council. Committee. Conducting council. Has some personal difficulties today. And today, therefore, pray for it. He is also obtained consent from the Land Council of the other side. The prayer for the age prayer for the matter can adjourn to be listed after 4 weeks. Okay.
Much obliged.
Mayor, Lordship, I like to mention an unused matter.
What is this matter about?
AB matter to be listed
Today?
today. Yes. We have filed AB today So we would like the matter may be taken up today itself.
Tomorrow,
Your Lordship, tomorrow it will be given.
There is difficulty there tomorrow, the politics.
where is the mention memo? Already filed, already registered.
Yes.
When it was filed?
Minutes.
Hmm?
Before 15 minutes. Lordship may taken up the matter at last time. It is
Okay,
great.
okay.
Oh, bless.
Item number 1. May I please, my lord?
Yeah.
My lord, this revision petitions file arising out of impugn order dated 5/9/25, being passed by the Honorable Court of District and Session Judge of UP. My lord, the factual metric of the case is that I of the case was summoned by the learned trial court since last 3 occasions on different dates: 7/8/24, 8/1/25, 3/4/25. And thereafter on 36/25, I of the case was appeared before the Honorable Session Court, and he was examination of chief was conducted. But on that particular day, my lord, I as a leading counsel, so I could not able to appear on the particular day and could not able to cross-examine the IO. So thereafter, Honorable Court has passed an order that cross was declined by the defense counsels. In fact, my lord, defense counsel one Mr. T. Thaddeus was appear on behalf of the accused person. He was praying before the learned trial court that cross may be reserved for the day. And even we will pray that we will also able to pay the cost of the traveling expenses of the PW12 as a IO, my lord. So it was not considered, my lord. So, my lord, thereafter, I filed one misapplication offering under section 311 for recalling of PW12 as a IO. So he was very important witness in the case, but that was also not considered by the learned court. So, my lord, lordship may come to page number. Page number of annexure 6, page number 20 is the impugn order. May I read, my lord?
Pradesh, 26.
Yes, my lord. Page number 27 to 28, my lord. Is the impugn order, my lord. May I read on, my lord?
Yeah.
Today, present case speaks for appearance the accused and examination of the accused under section 313 of CRPC. Accused person, namely How Chuka, is present along with his learned defense counsel, Mr. N. Rama. State is division of learned PP, Ms. J. Roji. Seen criminal miss case number 191/25, filed under section 348 of BNS, praying for recalling of PW12, namely Inspector Padi Paying for his cross examination. Copy of the petition is served upon learned PP. Having
Okay,
heard submission made by
Please
learned.
come to page 19.
Yes, my lord.
IO is present.
Yes, my lord.
Is examined as PW so and so
Yes.
and
So-
discharged after cross-examination.
Yes, my lord. On this,
Cross-examination declined.
my lord, in fact, my associate was appearing in the case and he was praying for reserve of the cross of PW12. But in order, it seems that cross was declined by the
Oh,
defense.
you are making allegation against the conducting judge,
No,
No.
I'm not.
trial judge.
No, I'm not alleging, my lord.
Then-
So, my lord, so on that particular day, I was out of station, so could not able to, due to unable to circumstances, my lord, I was out of station and could not cross-examine the PW12, my lord, as a IO. So, my lord, thereafter, I made praying that the IO is the metal witness
No,
in the
see,
case.
how do we allow after you decline? How the trial court will allow you once you decline? And how he can allow you to cause trouble to the officers?
My lord, in fact, he was summoned by the trial court last 3 occasions, my lord. So on that particular day, he was appear and we could not able to cross-examine, my lord, because IO of the case.
That cannot be reason for your declining, or there cannot be reason because you yourself has declined.
My lord,
But you were represented only, the accused was,
yes,
Yes, and-
accused was,
then only he declined.
Maybe, my lord, my associate was a junior to me and he was not able to understand.
No, when, after fixing the dates for examination of the important witness like IO,
Yes.
why you should remain absent?
My lord, last three occasion I was
Cannot,
present.
cannot.
I was present, my lord. So
It's very difficult. in the
my
trial court.
prayer is that, my lord, since
When the witness exists, the Rana court has also observed that pending for 7 years, more than 7 years.
yes, that is
And
there,
because
my
of
lord.
such,
That is dear, my lord. But
See,
my lord,
then-
IO of the case is one of the important witness in the case to cross-examine.
that is why he was appearing on that, you knew it very well.
My lord, in fact,
And then the counsel was in fact appearing. He appeared and declined. What is the provision after decline?
my lord, in fact, so I have filed application for recalling of the IO.
that
Maybe,
was
my lord, because of
That was
the
refused.
wrong submission being made by the my associate. So it was recorded as decline, my lord.
No, the judge himself has remembered. He was the one who passed the order on 3625 also,
3625.
and then the rejection order also. He knew it, and then he has recorded his observation also. He remember everything.
My lord,
So what is this? How the trial will progress?
my lord, with my submissions, I have some judgment from the Honorable Apex Court.
Maybe,
Honorable
maybe. But then here is a clear case, you have declined.
My lord, maybe that was the wrong submission being made by my associate, my lord. So, I hope the case is one of the important witnesses, my lord.
See,
So, I may have
one person
opportunity to
decline
cross
and
it.
other person comes and says that it was a wrong submission. And tomorrow someone comes and then you made a wrong submission, then how long it will go on like that?
My lord, this was the first time I was appear on that 30.
How many times are you required to appear?
We were just praying for my lord, just once to recall him and just cross-examination, my lord. Only cross-examination, my lord.
See, that is why
And
the
even my lord, I hope the
defense
case, he was
counsel-
agreeing
when the
to,
case goes against them, trouble the witnesses. When they come,
I understand.
they refuse to examine or decline or remain absent. So that is why it doesn't, the trial of the case doesn't progress. And same case, it appears, it happens like that in this case.
My lord, my prayer is that
Now,
LCR.
we cannot encourage such things. We have seen in the trial court also, the counsel, I don't know why.
But
This
my
is
lord,
not a good
last
tactic.
3 occasion, I was continuously appearing in the case, but I was remain.
But when
not
the
turn up.
witness comes, you remain absent.
But unfortunately, on
But
that
in your,
particular day, my lord,
on your behalf, some other advocate was present. You mean to say that he was incapable? At least he knows, he's supposed to know whether decline or to make a prayer.
my lord, as per his submission, he prayed learned trial court that cross may be reserved on that particular day. But later on, we come to know that the order it was declined, my lord.
What is the stage now? 313.
313, my lord.
At this stage.
Three,
At this stage.
prosecution has examined and crossed all to 11 PWs, and this is 12 PWs. So only IO is remaining for cross examination, my lord. So, my lord, we are also agreed to bear up the traveling expenses of the IO, my lord. We
The
will
IO
also-
is the official witness.
Yes. So he's one of the important witness in the case, my lord. Just to fair decision of the case, he may be allowed to, we may allowed to cross examine.
See, the lackadaisical approach of the Atlantic Council, I think he also knew it very well. That is why he has made this kind of observation. And the importance of witnesses appearing before the court and the importance of cross examination, you are supposed to know. But then you see, you trouble the court as well, not only the witnesses. How long the court will carry on with such cases or repeatedly summon one witness for again and again? Very difficult.
So this was the first time he was appear, my lord. On 30th June. he was
IO
first
need to
time.
appear only once only.
Yes. So on that, unfortunately, my lord, due to unavoidable circumstances, I could not able to cross-examine.
Yes.
Lordship, as per this orders, Lordship, they themselves, Lordship, declined the cross-examination, Lordship. So upon that, Lordship, on 5/9, Lordship, they have filed before the Lordship session court for the
Whether
recording. That
record
is,
need to be called for.
Lordship, Lordship,
LCR may be called.
What is the allegation against that?
Allegation is, my lord, section 306, abetment of suicide, my lord. Allegation that husband has abetted and wife has committed suicide.
Or what is the submission?
Lordship, now, Lordship, they have come before the honorable court under Lordship for revision, Lordship. So, Lordship, as per the section.
When the state is fixed for 313?
My lord, 11/11/2025. 313 is fixed for
Yeah.
cross.
We can just see and pass order. See the
Lordship,
record and pass order.
yes, Lordship.
Pardon, Mr. And Rama, counsel for the petitioner. This is an application filed under section 438 and 442 BNSS 2023 against the, that is a criminal revision filed under section 438 and 442 BNS 4setting against where is the info order?
So it is in page number 27.
Against order dated 5/9/2025
5/9/25,
passed by the Line Session Court in this case within bracket CRL criminal bracket close number 191/2025 in session case number 51/2018 in arising out of the Dorno PS case number 02/2016. Whereby the application filed by the petitioner under section 348 BNSS has been where is the info order? Rejected. Filed under section 7 for recalling of the witness for cross-examination has been rejected. Call for the scanned copy of the trial court record. But since Ms. L. Haggett, Lane additional people accept notice on behalf of the respondent, no formal notice need issue. This is matter. Then it will be only after vacation.
my lord, after that.
Okay. Immediately after vacation. Okay.
Much.
Yes, sir.
Item number 2.
My lord, this criminal petition is filing for causing of FIR jointly filed by the accused victim and informant, my lord.
What is the joint petition?
Yes, my lord, joint petition filed.
What
by-
was the allegation?
Allegation is, my lord, extortion of some petrol of cost rupees 700, my lord, by the accused person. The fact of the case is that, my lord,
Whether arms act also registered?
no, my lord, arm is not registered. Because that was a service gun which he was called on that particular. He
You-
was a PRO of a PSO of the then Vice Chancellor of Rajiv Gandhi University. So while he is going to perform his duty on that particular day at morning, on the hurry, he could not bring his money first. And he went to a nearby petrol pump and filled petrol of rupees 700. So thereafter, we talked with the petrol pump owner and employee, but there was some argument between the parties. And accordingly, later on, he was left the petrol pump. And in the same day, on the evening, the FIR was registered against this accused person.
Definitely. So
Yes. So, my lord, now
then
the
there
owner
are-
of the petrol pump and victim, they have mutually settled, and 700 rupees was also paid by the accused. So this is joint petition. My prayer is that the speed case to be quashed, FIR, my lord. FIR is in page number, lordship. FIR is page number 14, my lord. Yes, I read out, my lord.
just a minute.
15.
392.
390, 392.
Yeah. So thereafter, investigation complete.
Investigation completed, and my lord, 2 witnesses examined, including
Okay,
the
already
complainant.
examined.
Yes, including the complainant and one of the security officer. Victim is yet to be examined.
Yes.
This is not,
390.
not at all a fit case to be quashed, my lord. Interestingly, the person involved is a police officer. He's using his firearm and extort petrol from the petrol pump without giving any money. Now he himself is admitted that he was not carrying a money. For that, he ought to have
He was
requested the
carrying a gun.
petrol pump, but showing his service revolver to that person and taking petrol. And now, your lordship, the interesting part here is the prosecution sanction is also not required in this case, but sanction is also been granted by the concerned authority, ma'am.
Okay.
It's page number 26, ma'am.
But then arms act is not there.
But it's still, your lordship, my lord, sanction is not required in this case. But it's still, what I'm trying to say is, my lord, even the
So-
authority
Hmm.
has found him, your lordship, found the prima facie case against that official, my lord, the IRBN official, my lord. And if this matter is quashed, my lord, this is amounting to encouraging this police official, my lord, for misuse their power.
And when court, they'll pay the money, 700. Okay.
In their agreement, my lord, is in page number
On
40.
contest, that will fall for the
Charge
court.
only frame under section 392 of IPC, my lord.
Okay.
That is
No,
order.
no.
Charge frame
Have you
order
also
is page
annexed
number
the?
41,
have you
yes,
also annexed the?
Yes, my lord. Page number
No,
41.
no, evidence.
Yes, ma'am.
Evidence, the
Page 41.
deposition. Any material,
Page
where
41.
is the deposition of the witnesses, prosecution witnesses?
My lord, PW's deposition are not enclosed with the petition, but charge sheet I have enclosed.
We'll
and
see,
apart-
we'll see.
Yes, your lordship, but no stay, madam.
Now, trial is going on. No, okay. I've heard Mr. and Rama, non-counsel to the petitioner. I've also heard Mr. Theatre, Tanner Edison PP for the state respondent. The petitioner filed this application under section. Just a minute, okay? Which one is the informant?
My lord, 2 is informant. Petitioner number 2 is the informant.
And
3 is victim. The one
3 is victim means?
victim which the accused was argument with. There was no physical assault. In fact, argument was there.
From whom he was extorted the petrol.
Filling up the petrol, so there was some argument.
By filing this joint petition, the petitioners, joint petition under section 528 of the BNS, as the petitioners praised for setting aside and quashing of the FIR dated 26/8/2020, registered is term of PS case number 68/2020. No, GR case is also. No.
Here, case
Checking it
480,
and
madam.
crossing off
480.
GR case number 480/2020 arising out of the
PS
the
68 of 2020.
PS case number 68/2020 under section 392 IPC. Stop. Huh? Call for the scanned copy of the trial court record issue notice. Since Mr. Piete, Lieutenant Additional PP, appeared and accept notice on behalf of the state respondents, the formal notice is waived. Stop. Huh? Please this matter.
23rd, madam.
Okay, on 23rd of
Oblige.
October. Huh? Of October.
Item number 3.
Much.
Wait, please.
Yes.
The petitioners before lordships, my lords, are candidates for the Arunachal Pradesh Engineering Service examinations. These are the candidates, my lord, who were declared to be eligible subsequent to an order passed by this honorable court. One set of candidates numbering around 1200 appeared on 18th, 18/9, my lord. 346 candidates. And now they expect us, because of the wrongdoing, they declare this result so late, they expect us to be prepared for these written examinations in 9 days. And in the meantime, my lord, those 1200 candidates, they have now got more than 60 days. And why it happened? Because of their act, not me. I saw from the records, my lord, the action of the Public Service Commission is absolutely arbitrary, irrational, unreasonable, and perverse, my lord. And it's squarely hit by the, my lord, this Wednesday's principle of unreasonableness. My lord, will kindly take note, my lord. This examination, Arunachal Pradesh Engineering Service examinations, is being held after a gap of 8 years. The last examination was held in 2017, pursuant to an advertisement in 2017, results were declared in 2019. Thereafter, in 2021, another advertisement issued. We all know what happened to that because of the rampant corruption in the commission, my lord, that had to be cancelled. Absolute rampant corruption. Commission's fault. That was to be cancelled. Each and every employee of the commission has now been transferred out. We were expecting something better. Now this has happened. So, Lordship will kindly have page number 63, only for the purpose of showing what is the manner in which they're supposed to conduct the examinations. This is their manual, madam.
Yes.
Then my lord will have page 73.
Hmm.
Recruitment test. Yes, my lord. Good. Page 73.
Yes.
Serial number 11, Roman 11.
Yes.
Recruitment test. In case there are a large number of applicants for a service post, the commission, if deemed necessary, may conduct a recruitment test before the main written examination. So this is just a preliminary test. The examination consists only of the written test and the viva. In case there are a large number of candidates, they may conduct a preliminary examination, recruitment test. Now, your lordship may kindly have C, subclause C.
Yes.
Of the qualified applicants in this preliminary examination, 12 times the number of advertised posts, or as decided by the commission, will be admitted to the main examination. So, my lord, total number of posts into 12. That is the number of candidates they are supposed to, my lord, call for the main examinations. Now, your lordship will have the advertisement. I'm just showing, my lord, what happened and why the litigation happened earlier also. The advertisement is at, my lord, page 83. Various work departments, it's a combined examination.
Yes.
Then your lordship will kindly have page 86.
Yes.
Eligibility, my lord, got it?
Hmm.
Yes. We are concerned with post up to serial number 7.
Yes.
Assistant engineer civil for public works department, public health engineering, UD, urban local bodies, hydropower development, rural works development, rural work department, and water resource department. There are 7, my lord. Now, out of this, my lord, will kindly note up to serial number 4. There is urban local bodies. Only civil engineering graduates are eligible. Then, my lord, will kindly have the next 3 posts: hydropower, rural works development, water department. Here, the civil engineering candidates are eligible here also. Additionally, my lord, agricultural engineering candidates are eligible. So total post is 102 for the 4 posts and 34, 136. So 136 into 12, my lord, actually comes to more 1600 something, my lord. For these 3 departments, my lord, additionally, agricultural engineering is required. As my lord got it. We all appeared in the exams, the result notification at page 90. At page 91, the lordship will see. This is dated 30th of July 2025, your lordship will notice.
Yes.
Your lordship will have page 91. This is in respect of the first 102 posts. Your lordship will note there are 1205 names here, 91 to 93. 1205. This is in respect of 4 posts. The first 4 posts where the civil engineering candidates are only qualified. Now, additionally, this at page 94, another list comes out where the agricultural engineering along with the civil engineering candidates are also qualified. This contains the names of 414 roll numbers candidates. So total comes to around 1619. Very well, my lord, the 1:12 ratio is being followed. A bit less, but whatever. 414 roll numbers, my lord. But here, 362 roll numbers candidates who appear here at page number 91 are again included. Am I clear, man?
Yes.
In the page 91 list,
Included here in the 414 also.
yes, 362.
Okay.
They have been double entry. So that is how 362 from civil engineering are there, and 52 from agri engineering are there. 414, double inclusion of 362. That is how, my lord, being agreed, we say there could not have been any segregation. The manual does not provide so. The advertisement does not provide so. Agriculture, civil engineering candidates are eligible for all these 7 departments. You could not have done it. They did not, obviously, we filed representation. They did not act upon it. So ultimately, we have to approach this honorable court. Page 114. 3 writ petitions were filed. 380 was filed by qualified candidates whose names are in the first list but have been deprived from appearing for the other 3 departments. 382 were.
Which one?
380.
Writ petition.
Yes. 3 writ petitions, 380, 382, and 404.
Okay.
It's a common order.
Okay.
I'm just pointing out 382, 80 was filed by candidates whose names appeared in the first list, but were barred from appearing in respect of the 3 departments where agriculture engineering is also qualified.
Okay.
382 was filed by candidates whose names did not come. And 404 was filed by agricultural engineering candidates whose name also did not come. Ultimately, your lordship will kindly have paragraph 11 of this order, this interim order. My lord will kindly note this was on 3/9/2025, 3rd of September. Exams that were scheduled on 6th and 7th of September. My lord will kindly have paragraph 11. at page 139.
Yes.
Having heard the learned counsel for the parties and upon perusal of the pleadings available on record, it is seen in the writ petitions that there is a list which is published by the APPSC, which is shown to be a select list for 102 vacancies of assistant engineer for appearing in the written examination for selection and appointment in the department of such and such. But it's seen that it contains 1,205 candidates by following the ratio of 1:12 in terms of the vacancies stated to be available and advertised. Similarly, APPS also published the select list of candidates with the roll numbers only against 34 vacancies of assistant engineers in the department of such and such for appearing in the written examination. A perusal of these two lists reflects that several roll numbers which are reflected in the list of selected candidates published against 102 vacancies are also reflected in the list of candidates against 434 vacancies. Consequently, many of the selected candidates in the list one are also included in the vacancies reflected for 34 vacancies. The segregation prima facie, as it appears to this court, will have effect on excluding candidates from the zone of consideration who would have otherwise been included. Had the segregation not been carried out by the APPSC, the advertisement does not reflect anywhere that the zone of consideration will be worked out on the ratio 1, but it's mentioned only the guidelines under such and such, which is a part of guidelines published by the APPSC. Neither the guidelines nor the advertisement reflect anywhere that for the 136 vacancies the assistant engineer sought to be filled up under the various departments will require segregation after the preliminary examination. Consequently, prima facie, it appears to the court that had the merit list of 136 vacancies have been prepared on the basis of guidelines on the ratio 1:12, then the persons who claim to be left out of the zone of consideration accordingly, my lord, since only 49 petitioners were there who had not qualified, this honorable ultimately directed that the petitioners be allowed to appear in the exam. That was the word used. Though in the writ petition I had made a prayer that, my lord, the select list should be published again of the 362 candidates, but this honorable court in his wisdom felt that let the petitioners appear. So, my lord, I pause here, my lord. When that order was passed, I told the petitioners who were my clients, I told them, maybe somebody of you will not like this. I, as a reasonable man, not as a lawyer, I thought, obviously all the petitioners will not qualify. Only 49 have come. 362 should have come because there are double 362. As a reasonable man, I would think so. I would like to think so, even if I say so myself. I thought the Public Service Commission will now obviously declare the result of 362 candidates, and some of my clients may not come, and I advise them accordingly. What they do, at page 142, my lord, will kindly see the date, that exactly on the next date, on the 4th, they postponed the exam. This was scheduled to be held on 6th and 7th. 4th of September. They postponed it. They already fixed a date. 28 and 29. Already. I'm pointing it out for a reason. My lord, kindly 28, 29, they have already fixed it on 4th.
Yes.
Then thereafter, they goes on to file the review petition at page 143.
Okay, after fixing.
Yes. This was signed on 5th. In fact, 5th is actually, my learned friend Ms. Anju will correct me. 5th was Friday, they ultimately filed it on 8th. Though copy was served to us on 5th. Your lordship will kindly have page 172. This is a review petition. After 4th, they took this decision. My lord, just see, my lord. They've already fixed the date. Then thereafter go for review, my lord. Why don't they wait for the result of the review? Declare the result. That is what they wanted. They wanted that this is signed on 5th. Now, your lordship will have the prayer of the review petition. At page 170, what they wanted. Obviously, as I was saying, they wanted now, since the Honorable Court has said that the petitioners allowed, then everybody who comes in merit should be allowed. That was their prayer, in 1:12. They have in the review petition itself said, of the 49, 27 does not qualify, 22 qualifies. So, those who comes in merit 1:12, they should be allowed. That decision they already taken. My lord, you see, allowing only candidates who secured higher marks than the petitioner and
Where are
all,
we reading?
page 170.
Yes. The prayer.
It is hereby prayed that the Honorable may please to modify the order that is such and such, and to modify paragraph number 13 of the order to the extent I,
Yes.
specific directions to the commission.
Hmm.
They're seeking a direction against themselves, allowing only candidates who secured higher marks than the petitioners and falls within the zone of consideration in the specified ratio of 1:12 as per the revised list. So that is what they wanted, 1:12, and excluding the petitioner who does not come into 1:12. That is something I have told the petitioner already. So of the 49 petitioners, 22 already qualifies. In 382, 27 goes out. Very well, if we don't come, we don't come. So this is the prayer they are making. And before that, I've already scheduled the examination. That is why I say unreasonable. Then ultimately, my lord, we have not been able to produce a copy of the order. It is not uploaded. Order, 18th. The review petitions came to be heard on 18th. I have made a statement in the writ petition. At 2 o'clock, I appeared through VC. My learned friend appeared in person at Guwahati, Ms. Anju. This honorable court, I accepted that only those candidates who comes in the merit has to appear. That's a reasonable thing. I accepted, I considered that was allowed. The honorable court reviewed the order and said only these 27 candidates who does not come under merit should not be allowed to take part in the examination. That was at 2 o'clock, my lord. The order was passed sometime around 2:30, 2:45. Then, in the almost around night time, this notification comes out at page 173.
Yes.
346 additional candidates comes. Their names are declared. They say they are also eligible now to take part in examination. Page 173.
Yes.
Now, but they declared a result on 18th, but they continue with the date they fixed on 4th, before the review was filed. What can be more unreasonable and arbitrary, my lord? The candidates listed in Appendix 1 shall be provisionally allowed to appear in the written examination scheduled on such and such, subject to final judgment such and such. Now, the attitude of the Public Service Commission in the APRs is, as if they are doing us a favor. They are not doing us a favor. We have fought for this and have got this. At the intervention of this honorable court's order, that the 3-9 we have passed this order. Now, my lord will kindly recall the first result is of 37. They were initially given around 35 days. At the intervention of the court, now this has come. And 18, my lord, 29, there, 28, there is an exam. We get effectively 8 days. My lord, is this reasonable, my lord? I am aware, my lord, the Public Service Commission is an autonomous body, but it is also a public body. Discretions are not unfettered. Discretion will have to be in public good, my lord. I will just rely upon one judgment, my lord. 1994, 6 SCC, 651. Para 77 onwards. And one, my lord, finds that this is arbitrary, irrational, and unreasonable, being hid by witness principles of unreasonableness, my lord will interfere, my lord. My lord's hands are not tied. Page 677, my lord, with 11 portions. Paragraph 77 onwards.
Yes.
77. The duty of the court is to confine itself to the question of legality. Its concern would be whether decision-making authority exceeded its power, committed an error of law, committed a breach of the rules of natural justice, reached a decision with no reasonable tribunal would have reached, or abused its powers. Therefore, it is not for the court to determine whether a particular policy or particular decision taken into fulfillment of that policy is fair. It is only concerned with the manner in which the decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action, my lord, is subject to control by judicial review can be classified as under. It's an administrative action, my lord. Illegality, the means the decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. Irrationality, namely, witness is unreasonableness. Procedural impropriety. The above are the only grounds, but it does not rule out addition of further grounds in the course of time. As a matter of fact, in such and such, Lord Diblock refers specifically to one development, namely the possible recognition of the principle of proportionality. In all these cases, the test to be adopted is that the court should consider whether something has gone wrong of a nature and degree which requires an intervention. What is this charming principle of witness versus unreasonableness? Is it a magical formula? In R versus SQ, Lord Mansfield considered the question whether mandamus should be granted against the College of Physicians. He expressed the relevant principles in two eloquent sentences that gained greater value 2 centuries later. It is true that the judgment and discretion of determining upon this skill, ability, learning, and sufficiency to exercise and practice this profession is trusted to the College of Physicians, and this court will not take it from them, nor interrupt them in the due and proper exercise of it. But their conduct in the exercise of this trust, thus committed to them, ought to be fair, candid, and unprejudiced, not arbitrary, capricious, or biased, much less led by resentment on personal dislike. To quote again, such and such as under. The assertion of the claim to examine the reasonableness being done by a public authority inevitably led to differences of judicial opinion as to the circumstances in which the court should intervene. These differences of opinion were resolved in 2 landmark cases which confined the circumstances for intervention to narrow limits in such and such. A specially constituted divisional court had to consider the validity of a bylaw made by a local authority. In the leading judgment of such and such, the approach to be adopted by the court was set out. Such bylaws ought to be benevolently interpreted, and credit ought to be given to those who have to administer them what they would be reasonably administered. They would be held invalid if unreasonable, where, for instance, bylaws would found to be partial and unequal in operation, my lord. We are getting 9 days and they're getting 65 days. Unreasonable in operation as between different classes. If they were manifestly unjust, if they disclose bad faith, which is in this case, or if they involve such oppressive or gratuitous interference with the rights of citizens as could find no justification in the minds of a reasonable man. I pause here, my lord. Would the reasonable man, my lord, first, my lord, defer the examination, thereafter file a review? Lord Russell emphasized that the bylaw is not unreasonable just because particular judges might think it went further than was prudent or necessary or convenient. In 1947, the Court of Appeal confirmed a similar approach for the review of executive discretion generally in Associated Provincial Picture Houses Limited versus Wednesbury Corporation. The case was concerned with the complaint by the owners of a cinema in Wednesbury that it was unreasonable of the local authority to license performances on Sunday only subject to a condition that no children under the age of 15 years shall be admitted to any entertainment, whether accompanied by an adult or not. In the extempore judgment such and such, due attention to the fact that the word unreasonable has often been used in a sense which comprehended different grounds of review, where it's said that dismissal of a teacher for having red hair, cited as an example of a frivolous and foolish reason, was in another sense taking into consideration extraneous matters and might be so unreasonable that it the court is entitled to investigate the action of a local authority with a view to seeing whether or not they have taken into account matters which ought to have been taken into account, or conversely, they have refused to take into account or neglected to take into account which they ought to have taken into account. Once that question is answered in favor of the local authority, it may well be possible to say that although the local authority have kept within the 4 corners of the matters which they ought to consider, they have nevertheless come to a conclusion so unreasonable that no reasonable authority could ever have come to it. In such a case, again, I think the court can interfere. The power of the court to interfere in each case is not as an appellate authority to override the decision of the local authority, but as a judicial authority which is concerned only to see whether the local authority has contravened the law by acting in excess of power which Parliament has confided in them. The summary by Lord Green has been applied in countless subsequent cases. The modern establishment principle is found in the places of such and such. By irrationality, I mean what can now be secondly referred to as Wednesbury's unreasonableness. It applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible man who had applied his mind to the question to be decided could have arrived at. This is exactly the case in my humble submission. At this stage, Supreme Court may be quoted. A decision of a public authority will be liable to be quashed or otherwise dealt with by an appropriate order in judicial review proceedings where the court concludes that the decision is such that no authority properly directing itself on the relevant law and acting reasonably could have reached it. Two other facets of evaluation may be considered. It is open to the court to review the decision maker's evaluation of facts. The court will intervene where the facts taken as a whole could not be logical or warrant the conclusion of the decision maker. If the weight of facts pointing to one course of action is overwhelming, the decision of the other way cannot be upheld. Thus, in Emma Hotel versus such and such, the Secretary of State referred to a number of factors which led him to the conclusion that a non-resident members bar in a hotel which is operated in such a way that the bar was not an incident of the hotel used for planning purposes but considered a separate use. The Divisional Court analyzed the factors such as that. The conclusion, having done so, set it aside, said that we could not see on what basis the Secretary of State had reached this conclusion. A decision would be treated as unreasonable if it is impartial and unequal in its operation as between different classes. In my humble submission, that is exactly what has happened, man. It is not my fault that these 346 candidates have been declared eligible on 18th. It is on them. The court has, this honorable court has prima facie come to a view that the action was wrong. Others should come in, and that is exactly what wanted to do, and that is why they filed a review petition. But before that, they have already fixed that date. In my humble submission, by totally absurd, perverse, and unreasonable being hit by the unreasonable in minors, my lord will direct them, my lord, to give a reasonable period so that the candidate whose name has now appeared, my lord, gets an opportunity. This is discriminatory also, my lord. And that's all, my lord, subject to what my learned senior friend says.
Yes.
In fact, Lordship, I have so many arguments for that. Because, but there's a message right now saying that we can give 1 month time.
Okay.
So without saying, and I'll have to convey that message to the court.
That appears reasonable.
But so anyway, Lordship, I'll
Yes. And that is
I'll
all
give
what we wanted.
Okay, then what we'll do,
1 month, then the
we'll
petition
dispose
may
of,
be-
My lord,
dispose
dispose it
of-
of.
then in that case, we'll dispose of,
All
by
instructions.
giving 1 month,
Yes.
not 4 weeks, age break. One
1 month, 4 weeks, same
4
thing,
weeks,
my lord, same thing.
Same thing. Okay, then we'll dispose of giving 1 month time and then giving Public Service Commission.
Yeah.
Arunachal Pradesh Public Service Commission to refix the date.
Yes.
Okay, so because it is reasonable,
Yeah.
they should also get some time to
Yes.
prepare. Okay, I'll dispose of
At
that.
last, they are being reasonable, my lord.
Yes.
Then, but they, we had to fight it.
No, no,
but
this
it's a
generally-
difficulty.
Because
Could have
the
done it.
other has got more than 60 days.
Yes.
And then this, they have got only 9 days. It was, of course, unreasonable. So now it's good. Okay,
Obliged.
happy that they have agreed. I was also expecting this.
Yes, yes, my lord. Everybody, my lord.
Yes. Okay, I'll dispose of.
Anyway,
Obliged.
Item number 5. Item number 4.
Not those, huh? Okay. Okay,
May I, Your Lordship?
Yeah.
Your Lordship, I'm for the respondent number 2 in this case, Your Lordship. Four.
you are for respondent.
Respondent number 2, Your Lordship.
Okay, who is for
Your
the
Lordship
petition?
may refer to earlier order since January, Your Lordship. This petitioner, they have remained absent since January, Your Lordship. And there's one order, Your Lordship, dated 27/6/2025, where this court has noted that on many multiple occasions, they have been remained absent. Therefore, Your Lordship,
This
they-
is, it's, okay,
item number 4.
petitioner was supposed to file additional affidavit.
Yes, Your Lordship. So, Your Lordship, since January, they have remained absent. And since long back, they were supposed to file an affidavit, but then time and again they have not filed yet. So your lordship may refer to one order of 27/6/2025, your lordship. This honorable court had granted in time for them to file a necessary affidavit. Also had noted that last opportunity has given to them 27/6/2025.
Okay. Last opportunity.
Yes, last opportunity have given. Also, this court has noted that the due process will follow thereafter if they have remained absent. Thereafter, your lordship, on two occasions, they have still remained absent.
What is this petition for?
This is for quashing of quashing petition, your lordship.
Oh.
We are basically challenging two order, your lordship. One is for that NPAW issues against the petitioner, and then another is that proclamation has been declared against the petitioner, your lordship.
Yes.
So therefore, my humble submission, your lordship, this petition may be disposed of on default, your lordship. Since on multiple occasions they have been granted time, and time and again they have remained absent. So my humble submission that this may be disposed of on default, your lordship. Since January they have remained absent, your lordship.
None appears on behalf of the petitioner on court. Where Mr. Ms. Hage, then additional PP for the state, and Mr. Siri,
Ji Singh, your
Siri, Land Council for the respondent number
two.
How many respondents are there?
There's two respondents.
Okay. Present staff. The record details sir, on 27/6/2025. When the Land Council for the petitioner was remained unrepresented, this court has given Land Council given last opportunity to the counsel for the petitioner for appearance, or else necessary process will follow. Thereafter, on 23/7/2025 and on 6/8/2025, also the petitioner remain unrepresented. But today also, when the matter was called for, the petitioner is when the petitioner remained absent without any steps. From the above, it appears that the petitioner is no longer interested to pursue with the matter any further. According to this criminal petition, is dismissed for non-participation. Okay.
I do agree.
Item number 5.
Yes, Your Lordship, the present petition is for the criminal revision petition aired on the judgment of 15/7/2024 passed by the learned GMFC Code UPI, Your Lordship. So, Your Lordship, this is not a case of denial of liability, Your Lordship. From the very beginning, the petitioner admitted for the settlement amount, which is 65 lakhs, Your Lordship. In fact, they have already paid 44 lakhs, Your Lordship, as an installment, as directed by the learned trial court, Your Lordship. Your Lordship, we have already paid whatever amount, which is 65 lakhs, Your Lordship. We have already made that payment, Your Lordship. Today, we are here for the interest amount, additional interest amount of 5 lakhs passed by the learned trial court, Your Lordship. Your Lordship, on dated 5/7/2024, the date of judgment, my client had arranged the final installment of 21 lakhs by the demand draft, Your Lordship. But unfortunately, on that day, we got late to reach the court, Your Lordship, by the few minutes, Your Lordship. So by then, the judgment had been already pronounced, and the complainant already left from the court premises, Your Lordship. So because of that only, this judgment has been passed, Your Lordship. Your Lordship, you may see in the annexure number 4, page number 36 to 38, Your Lordship. Yeah, Your Lordship. This is the debit message from the app of Axis Bank, Your Lordship. So on that, in this date, this is page number 36, Your Lordship, annexure 4. Yes, Your Lordship.
36.
36, Your Lordship.
Yes, what is this?
So this is the, Your Lordship, screenshot of the Axis Bank, where it shows that 21 lakhs, Your Lordship.
Okay, paid.
Yes, the 21 lakhs.
Whether payment is disputed?
No, no, sir, payment is not disputed. But
Okay.
only the thing is, Your Lordship, before the pronouncement of judgment, we could not reach the court to pay the remaining amount, which is 21 lakhs, Your Lordship. We had
So
already
this
paid
was
44
paid,
lakhs.
when this was paid?
On 15, on the date of judgment, Your Lordship.
Okay, on the date of judgment?
Yes, Your Lordship.
Time?
Time 10:14, Your Lordship. 10:14, it's written in the screenshot, Your Lordship.
Okay,
Yes, it's.
page 36.
Yes, Your Lordship. 36,
Okay,
10:14:42, Your Lordship. So
Yes.
because of that, since it is a check bouncing case, we do not want to submit in check. That's why we have to make a DD, Your Lordship. And 13:14 was Saturday, Sunday, Your Lordship. That's why we could not make a DD. So on Monday, when I went to the bank and I made a DD, so before we reach the court, the judgment has been pronounced, Your Lordship. Your Lordship, the learned JMFC did not appreciate that we had already made a substantial payment, Your Lordship, which is 44 lakhs. That is a two-third of check bouncing case, Your Lordship, check bouncing amount, Your Lordship.
no, this amount is. Okay, total amount you were to pay, how much?
65 lakhs, Your Lordship. That is a settled amount.
65.
Yes, Your Lordship.
And
65.
out of 65, on the date when the judgment was pronounced,
Yes,
you
sir.
paid this amount. This is amount,
We
21
had
lakh
already paid 44 lakhs, Your Lordship, before the judgment.
before the judgment.
Yes, Your Lordship.
And how much of amount was yet to be paid?
21 lakhs, which we made it on the date of the judgment, Your
Okay,
Lordship.
this is last payment.
Yes, Your Lordship.
Okay,
So basically, we had paid all the amount, Your Lordship.
okay.
Yes, Your Lordship.
This they have received just before pronouncement of the judgment, according to you.
Yes, accordingly, they did not receive it because I made the DD, Your Lordship. So
Okay,
for that, I need to submit the DD before the honorable court. But
okay,
when I reach the court, the judgment has already been passed.
okay.
And Your Lordship, it's been like we
Now
wait for
you're challenging here by
Of-
this revision
Yes,
petition.
yes, Your Lordship. In the revision, it's a judgment. The judgment is on page number
You are challenging against what?
for the 5 lakhs interest amount, Your
Okay,
Lordship.
so since the payment is not disputed,
Yes,
so
Your Lordship.
you are on the interest
Yes,
amount,
Your Lordship.
interest of rupees 5 lakhs.
Yes, 5 lakhs, Your Lordship. So, Your Lordship, as per the section 138, there is no written that you have to pay the interest amount. But in the judgment, Your Lordship may kindly come to the page number 25 of the judgment.
The operative is 26.
Yes, 25.
Okay, 25.
Yes, Your Lordship, page number 25.
Okay.
The 16, para number 16, Your Lordship.
Hmm.
Further, it is not overlooked that the accused took and held back 65 lakhs of the complainant for a considerable amount of time, and thus it is imperative to reflect on the view of the Supreme Court in the case of H. Pukrast versus D. Paramasal. It was observed that, considering the length of trial and date of issuance of the check, it was necessary to award reasonable interest on the check amount along with the cost of litigation.
Reasonable amount.
Yes, Your Lordship. Your Lordship, interest. The word interest, Your Lordship, in the section 138, nowhere it is written that the court can ask for the interest. Compensation is there, fine is there, but not
Okay, this
interest
5
amount.
lakhs is interest.
Yes, Your Lordship.
Okay, not the fine.
Not the fine, Your Lordship. They have mentioned the word interest, the learned
Hmm.
JMFC, Your
Yes,
Lordship,
yes.
mentioned the word interest, not the fine, not the compensation.
Okay, okay.
And in fact, the judgment they referred in this H. Pukrast versus D. Parasmal, here it talks about the compensation, Your Lordship. Not the interest amount, Your Lordship.
Yes.
So, Your Lordship, our intention, Your Lordship will appreciate it that from the very beginning, petitioner never contested for the amount, Your Lordship, what is the complainant claim amount, Your Lordship. From the very beginning, with the, like, we have a genuine, like, honestly, we, from the very beginning, in the first hearing, the date of hearing when we entered and filed a wakalatnama, on that day only we stated that we are ready to pay whatever the amount is there. So we never contested the complaint claim by them, Your Lordship. So it was not intentionally, it clearly shows that we are genuine, Your Lordship. And there is no dishonest intention, Your Lordship. The core requirement of section 138 of NIA, it clearly says there should be intention, Your Lordship. But we have no intention, Your Lordship. Just because we did not get time to reach on the court and we did not hand over the DD demand draft on time, the judgment has been passed, Your Lordship.
Yes. So this matter,
Lordship, here the only question is whether learned trial court below can give interest to the
so
complainant.
probably 38 interest
Yes.
probably is not allowed.
Yes, I'll come to that, Lordship.
Hmm.
Interest is allowed, Lordship.
Okay.
I'll come to that. Lordship, on firstly, a few claims which my learned friend has made. After this judgment, this impugned judgment, they went for appeal before session judge.
Who they filed appeal?
Yes,
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 sir.
that is in
What happened to that appeal?
In
that
session
appeal
court,
was that appeal was dismissed because they had come before the court unclean hands. Firstly, the DD which they had referred to on 15th July, on the date of the judgment which they had given, DD does not mean that it has been credited to my account or the
Okay.
complainant's account. It basically means they have made the DD which will be deducted from their account only after I submit it before the bank.
Okay.
So claiming that they had made the payment on 15th July, that is on the date of judgment, is false. The DD was handed over before, in the presence of before the learned session judge on appellate court. That is in page number 32, Lordship. Page number 32. That is the appeal which was dismissed.
Okay, this.
After hearing, may I read, Lordship? After hearing both the learned counsels, page 32, Lordship. Pursuing the annexure, the court is of the view that admittedly the opposite parties, appellant had admitted their guilt of the due to pay rupees 65 lakhs to the applicant complainant. Hence, as per section 416 of BNS, the appellant are barred from filing appeal once they pleaded guilty. The court also found that the appellants had not come clean hand, as they have found that misleading the court with regard to junior counsel having made the accident on 15/7/2024, who actually met accident on 14/7/2024. Therefore, in view of the above facts and circumstances, the order passed by the learned court and so, hereby vacated and criminal appeals hereby dismissed along with the disposal of this IA. The learned counsel for the appellant is hereby directed to hand over the demand draft to the learned counsel for the applicant. On this very day itself, the demand draft was handed over. Now, the question regarding the interest.
So this was when this was.
This was on 3rd August 2024. Lordship.
And then the judgment, earlier judgment.
That is 15/7, 15 July.
Okay. So 15 July,
Yes.
although submitted, but then this was handed over on.
They submitted before the appellate court that they have already handed over the money on 15/7/2024 on the date of judgment. However, they could not reach the court because one of their junior counsels has made an accident, which they have also put in an annexure, which later on turned to be false because
Your
on
Lordship, I would like to clear it one thing. When you make a DD, the money has been deducted from your account as well, Your Lordship. We could not hand over him because he left the premises. I called him several times and asked him to come, court, please come to court to take that DD and let's come to before the honorable court. Just because the honorable court gave the interest amount of 5 lakhs, because of that only, he changed his mind, Your Lordship.
Anyway, Lordship, the only question which pertains today is that since they've already admitted the case, is that whether the learned trial court can give interest or not. That is the only question which this court has to determine, Lordship. So on the previous occasion also, on the last occasion, I have submitted one judgment, R. Vijayan versus Baby and another. Lordship.
Yes. Para.
Uh,
18, 19, 20.
Yes, para 18, 19, 20. Lordship, para 18. Having reached that stage, if some magistrate go by the traditional view that the criminal proceedings are for imposing punishment on the accused, either punishment or fine or both, and there is no need to compensate the complainant, particularly if the complainant is not a victim in the real sense, but is a well-to-do financial or financing institution, difficulties and complication arises. In those cases where the direction to direct payment of the compensation is not exercised, it causes considerable difficulty to the complainant, as invariably by the time criminal case is decided, the limitation for filing civil cases would be expired. As the provision of Chapter 17 of the Act strongly lean towards grant of reimbursement of the loss by way of compensation, the court should, unless there are special circumstances, in all cases of conviction, uniformly exercise the power to levy fine up to twice the check amount. Here, your Lordship may see, keeping in view the check amount and the simple interest thereon at 9% per annum as reasonable quantum of interest, and direct payment of such amount as compensation, meaning thereby, Lordship, when the court awards compensation, interest is also part of the compensation.
Here's also, they have not mentioned about the interest amount.
Let him finish.
Now, Lordship, Para 20 also, Lordship. One other solution is a further amendment to the provision of the Chapter 17, so that in all cases where there is a conviction, there should be a consequential levy of fine of an amount sufficient to cover the check amount and interest thereon at a fixed rate of 9% per annum interest, followed by an award of such sum as compensation for the amount. If we read the sentence as a whole, it can be understood that the interest and the fine together they becomes compensation, Lordship. Now, when the learned trial court has to award a compensation, they have to see the interest as well as the fine imposed. And now, coming back to our the impugned order, Lordship. Here, what learned trial court has mentioned. I may kindly come to page 25, Lordship. Paragraph 15, Lordship. Page 25.
Yes.
Para 15, page number 25. In the instant case, the accused has left no scope for rebuttal of the claim of the complaint, as they have not only admitted the claim and issuance of the check to the complainant, but also repaid substantial amount of the check amount. Further, it is not overlooked that the accused took and held back 65 lakhs of the complaint for a considerable amount of time, and thus in the imperative reflect of the views of the Supreme Court in cases so and so, it was observed that considering the length of the trial, issuance of the check, and it was necessary to award reasonable interest on the check amount along with the cost of litigation. Here, learned court has seen three things, considered three things. First, the length of the trial. Second, the date of issuance of check. Third, the cost of litigation. Comprising of these three ingredients, Lordship, the learned trial court has given the interest. Now again, Lordship, kindly come to page number 21. Lordship, the entire order, the impugned order, has to be seen in a holistic approach, Lordship. Here in page number 21, accused details. Your Lordship can see accused details. Here the word fine is mentioned. Rank of the accused, name of the accused, date of arrest, date of release of bail, offense charges with, whether acquittal or convicted, sentence imposed, Lordship. See it. Sentence imposed, 6 months imprisonment on default of payment of fine. This clearly indicates that the word interest, the learned court, by the word interest, he only meant fine and compensation.
Note the interest, Your Lordship.
Now again, since the learned trial court has mentioned H. Pukraj versus Parasamal, on basis of which this interest was given, this is the case which has been referred by the learned trial court. So, para 7 again. Again in para 7, the previous judgment which I have submitted, R. Vijay versus Baby, has been mentioned. So here the interpretation, Lordship, it is more clear here. So I'll read it again, Lordship. Again, para 7, Lordship. Again, in R. Vijayan versus Baby, this court considered the same question. The question was examined to examine the need to award compensation to the complainant. This court was of the opinion that the traditional view of the criminal proceedings are for imposing punishment on the accused, either punishment or fine or both, and there is no need to compensate the complainant, particularly if the complainant is not a victim in a real sense, but is a well-to-do financial and financing institution, giving rise to difficulties and complications. This court further observed that in those cases where discretion to the direct payment of compensation is not exercised, it causes considerable difficulty to the complainant, as very invariably by the time criminal cases decided, the limitation for filing cases would have been expired. This court further observed that as the provision of Chapter 17 of the NI Act strongly leaned towards the grant of reimbursement of the loss by the way of compensation, the court should, unless there is special circumstances in all cases of conviction, uniformly exercise power to levy the fine up to twice the check amount in view of the check amount and simple interest thereon at 9% per annum as a reasonable quantum of loss and direct payment of such amount as compensation. Here, if we read clearly, Lordship, again, this is interpreted, the language has been changed. However, this court has interpreted the R. Vijayan case. If you see, the simple interest thereon at 9% per annum as a reasonable quantum of loss and direct the payment of such amount as compensation. Meaning, there were, Lordship, here also the court has taken the view that the compensation includes of interest as well as the fine. This sentence itself clearly says. This court further observed that the direction to pay compensation by way of restitution in regard to the loss on account of dishonor of the check should be practical and realistic, which should not only mean not only the payment of the check amount, but interest thereon as a reasonable rate. In this particular case, the last para at Lordship. In the light of above judgments, we are of the opinion that the impugned order needs to be modified. Hence, we sentence the respondent accused to undergo simple imprisonment for a 6 month of offense under section so and so. Considering the fact that the check amount is rupees 6,19,488, we direct the respondent accused to pay compensation of rupees 10 lakhs. In this particular case, in fact, Lordship, for 6,19,488, rupees 10 lakhs was imposed as fine. In our case, the total amount is 65 lakhs. This 65 lakhs was given in 3 installments. So, considering the amount of the case, in fact, the 5 lakhs amount is very less, the interest amount.
Your Lordship, I would like to submit one judgment, rely upon one judgment, that is Damodar S. Prabhu versus Shahid Baba Lal.
Have you completed?
Let me finish.
Okay.
Now, Lordship, my prayer, Lordship. Since in the accused details, the learned trial court has mentioned the word fine. The only prayer is that this court may take holistic approach of the entire order, Lordship. And considering the loss suffered by the complainant because of the actions of the accused, this court may allow this 5 lakhs interest. In fact, I would pray that this court may modify the amount and increase the interest up to 10 lakhs.
Yes.
Your Lordship, I would like to refer one judgment, Damodar S. Prabhu versus Shahid Baba Lal, 3rd May.
Yes, what is this?
Yes.
Sarah,
Yeah, guidelines, the guidelines, Your Lordship.
guideline.
Yes, the guideline.
Okay.
Para number A.
Guidelines for, just a minute.
Yes, Your Lordship.
NIA case.
Yes, Your Lordship. NIA case only. In para 14, it is written that it may be noted here in section 143 Act. So it is comes under NIA Act only. And this is a Supreme Court judgment, Your Lordship. From the guidelines.
So which one is relevant for
Sir, the guidelines,
the
Your
present
Lordship.
case? Right there.
The guideline says, para A, that direction can be given that the read of summons be suitably modified.
Para?
A, sir, Your Lordship.
Hmm?
Yes, A. Guidelines. The guidelines which I have already
Yeah.
marked there, yes, Your Lordship.
Yeah.
Yes. The direction can be given that read of summons be suitably modified, making it clear to the accused that he could make an application for compounding of the offense at the first or second hearing of the case, and that if
Just
such
a
an
minute.
application,
You are reading which one?
A, Your Lordship, para A, the guidelines.
Okay.
Yeah.
Hmm.
May I, Your Lordship?
Yes, please.
Yes. That direction can be given that the read of summons be suitably modified, making it clear to the accused that he could make an application for compounding of the offenses at the first or second hearing of the case, and that if such an application is made, compounding may be allowed by the court without imposing any cost on the accused, Your Lordship. So this is a guidelines which is made like recently in 2024, Your Lordship. So we have already accepted, admitted in our first hearing itself, Your Lordship, that we are ready to pay. So this case is not about the denial of liabilities, Your Lordship. We are so genuine from the very beginning. We could have challenged, could have contested this case, Your Lordship, since they did not make a company as a party. We had a lot of reason to contest this case, but we did not do that with a genuine purpose. We thought that, okay, we are ready to pay. In fact, the court also gave the time to pay the whatever the check amount, that is 65 lakhs, Your Lordship. So we made a payment, 2/3 of payment. On the date of the judgment, because of Monday, Your Lordship, we could not make a payment on Sunday. Because of Monday, it clearly shows from my screenshot also, Your Lordship. So we made it in around 12 or 14 a.m., Your Lordship. And the bank opened at 10 a.m., Your Lordship. I have requested them to make a DD. And once DD made, the money has been deducted from our account. Only the things we could not submit it to him, Your Lordship. Now, all the accused, they all are family. The accused number 1 and 2, the petition number 1 and 2, they are 50 years old men, Your Lordship. And the wife, she is undergoing the treatment, surgery of both the knee for the replacement, Your Lordship. So they are facing that kind of difficulty. I have requested in the trial court also for giving some more time, but he did not allow. But anyhow, we have managed the money on the date of the judgment, Your Lordship. And since it was on Monday, so we could not make it on time, Your Lordship. Now, because of the COVID, they are facing difficulty, Your Lordship. Their business is in loss. So we have already made whatever settlement amount was there. From the very beginning, our intention was clear, Your Lordship. We were genuine. And also, Your Lordship, the section 138 is not for the panel, Your Lordship. Section 138, the main object is for the repayment, Your Lordship, which we have done it, Your Lordship.
Okay.
Yes, Your Lordship. This is my humble submission. You kindly set aside the order judgment. Yes, Your Lordship.
J. Jong, the Line Counsel for the petitioner. Also had Mr. H. Ape, Line Counsel appearing on behalf of the respondent. There is only one respondent.
Respondent.
Yes, yes.
Okay. Sole respondent.
Yes, Coach.
By filing this revision petition under section 397 of CRPC. This was filed, not CRP, it should be 401. Now it should be BNS. (438) of BNSS, read with section 442 of BNSS and section 4. Why you have put all these sections, CRPC also? Read with section 528 of BNSS challenging the order dated 15/7/2024 passed by the Lanet Court of Judicial Magistrates First Class UPA in CR case number 29/2023 under section 138 of Negotiable Instrument Act 1881, whereby the petitioners are directed for the because convicted for the offense under section 138 of NI Act, Negotiable Instrument Act, and sentenced to pay fine of compensation and against the and also against the order dated 3/9/2024 passed by the Lanet Session Court UPA, whereby the interim judgment dated
15/7.
Hmm?
15/7.
15/7/2024 was upheld. Okay, I'll pass the order.
Okay. Yes.
This board, no?
Item number 6.
Yes, Your Lordship. Your Lordship, the present petition is for the order dated 31/7/2024 passed by the learned CGM 0, Your Lordship, in the case of number 4/2023, whereby the trial court admitted the complaint case against the accused person petitioner by condoning the delay of 106 days in filing the complaint case and quashing of CR case number 4/0/2023 and all the criminal proceedings, Your Lordship.
This is between the same party?
Yes, Your Lordship, it is the same party. So basically, Your Lordship, that those checks were given as a security, but they have filed a same case in the UPA court as well and in the Zero court as well, Your Lordship. Your Lordship, the check,
No, this is arising out of the same transaction.
Same transaction.
same transaction.
Okay,
Yes, Your Lordship.
so,
So
Lordship, basically, the accused persons are service providers. They provide bank guarantees. So, this complainant was given bank guarantee of rupees 30 crore 88 lakhs. And in return, as their service charges, the
complainant,
yes, the complainant is the respondent here.
yes, yes.
The respondent had given 2 crore 15 lakhs for their service. Now, later on it was found that these bank guarantees were fake. And when the complainant asked them for to return the money, they gave 4 checks. Of these 4 checks, 2 checks were in favor of, in the name of the complainant, Mr. Khodagyati. The other 2 checks were in the favor of Vijay Innovative Banks. This, Mr. Khodagyati is the account holder. The complainant is the account holder of, attorney holder of this Vijay Innovative Banks. Now, the first 2 checks, it was for 65 lakhs, which was in the previous item number, Lordship. The other 2 checks
Just a minute.
Yes, Your Lordship.
The delay was condoned for filing what complaint? Complaint under what?
This 140,
One-
138, Your Lordship.
138.
140, yeah, 138 and 142.
Okay.
So Your Lordship, basically the check has been issued. May I?
Yes, yes.
Yes. So it's in page number 42. This is the check, Your Lordship. Page number 42.
42.
Yes, Your Lordship. This is the check, Your Lordship.
Hmm.
So basically, Your Lordship, number one, Finsperity Limited, issued by this company, Your Lordship, which is Finsperity Limited.
Hmm.
Yes, Your Lordship. In the check, it is written in the authorization signature, Finsperity Limited.
Hmm.
Yes, Your Lordship. But they did not make the Finsperity Limited as a party, Your Lordship. This is a company, Your Lordship. And in fact, in their petition, which is in page number 33, here also, it clearly mentions that whatever amount was deposited in the account of Finsperity Limited, Your Lordship. So the transaction happened between the Finsperity Limited and the Koda Yati, the respondent. So nowhere they have filed a case against my client, Your Lordship. So they did not make a party of the company, which is mandatory, Your Lordship. As per the section 142 of NI Act, sorry, 141 of NI Act,
Yeah.
page number 46.
Yes. Yes.
46, Your Lordship. Section 141.
Yes.
Yes, Your Lordship. If the person committing an offense under section 138 is a company, every person who at the time of the offense was committed, was in charge of, and was responsible to the company for the conduct of the business of the company, as well as the company, Your Lordship, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So, Your Lordship, here is also written clearly that company should be there if the offense committed by the company, since all the transaction was between the companies and the parties. So they did not make a company as a party. I have a judgment on that also, Your Lordship. I will submit it in later on. And Your Lordship, that is the first thing. And second, the check has been submitted and returned on 24/4/2023, Your Lordship. 24/4/2023. It's in next page of the petition. Next page in the sense, after 42, 43. Page number 43. Yes, Your Lordship. This is the return memo, Your Lordship, from the bank. The date is written 24/4/2023, Your Lordship. In the last, yes. So, Your Lordship, if this memo has been written on 24/4/2023, as per the section 138 clause B of NI Act, it is clearly mentioned that the legal notice has to be sent within 30 days, Your Lordship. That means they have to send a legal notice on 24/5/2023, Your Lordship. But, Your Lordship, they have sent a legal notice on 19/6/2023, Your Lordship. I would like to read the section 138 clause B, Your Lordship, of NI Act. Clause B, page number 42, 138 clause B. May I, Your Lordship?
Yes.
Clause B, the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to do the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. Your Lordship, it is a settled law that you have to send a legal notice within 30 days. It is clearly written here. But they have sent a legal notice on 19/6/2023, Your Lordship. The legal notice is in page number 47 of the petition. So they have sent a legal notice almost 2 months, Your Lordship. Whereas they were aware that one case is going on in their case was going on in the UPR court, Your Lordship, and there they got a favorable judgment also. They were aware, but still they did not file it on time, Your Lordship. So 2 months was gave, Your Lordship. And again, they have filed a complaint, Your Lordship, which is like 106 days delay to file a complaint. But in their reply, Your Lordship, in the reply of this petition, they have stated that it is between 25 to 76. But in the lower court, they have filed for delay, condonation of delay for 106, Your Lordship. So they are contradicting their own petition, Your Lordship. They have filed complaint, Your Lordship, after 106 days, Your Lordship. And Your Lordship, I would like to read the section 142, yes, clause B, Your Lordship, of the NI Act. Yes, clause B, Your Lordship, 142, clause B, NI Act, 48 page number.
Okay. Yes.
Yes, Your Lordship. Such complaint is made within 1 month of the date on which the course of action arises under clause C of the proviso to section 138, provided that the cognizance of a complaint may be taken by the government, the court, after the prescribed period, if the complainant satisfied the court that he had sufficient cause for not making a complaint within such period. So here also, it clearly stated that the complaint should be filed within 30 days, Your Lordship. But they have filed after 106 days, Your Lordship. In fact, the judgment of the trial court, Your Lordship, in the trial court judgment, I would like to read, Your Lordship. It's judgment, page number 27 and 28, Your Lordship, of the main petition, page number 27. Yes, Your Lordship. Para number 11. Section 138 of NI Act 1881 provides for the punishment of the drawer of a check if the check is returned due to insufficient fund or if it exceeds the amount arranged to be paid by the drawer. Section 142 clause 1 and clause B of the subsection clause B of the Act mandates that the complaint under section 138 must be filed within 1 month of the expiry of the legal notice period, failing which the complainant may seek condonation of delay. Therefore, the the court have the discretion to condemn the delay in filing the complaint if sufficient cause is shown by the applicant complainant. In the case of K. Bhaskaran versus Sankaran Vidyan Balan, the Honorable Court held that expression sufficient cause should be interpreted liberally to advance the cause of justice. So, Your Lordship, here the judgment which they refer, the learned trial court refer, this judgment is only talk about the jurisdiction, not about the condonation of delay, Your Lordship. The judgment refer is also wrong, Your Lordship. In this judgment, only that they're talking about the jurisdiction of the case, but not of the condonation of delay, Your Lordship. And Your Lordship, in this judgment, only the court talk about the complaint file within 1 month. What about that legal notice which has been sent after 2 months, Your Lordship? There's no explanation of it, Your Lordship. Number one, there's a mistake of they did not make a party of the company. I have a judgment of it. Hmm? Relevant para is in it's in second last page, Your Lordship. Point number 58 and 59.
Just a minute, huh?
Yes, Your Lordship.
Yeah, you have filed objection.
Yes, Lordship.
Okay. Just a minute. Huh? What is the status of proceeding before the trial
In the
court?
very beginning, Your Lordship. Very beginning. That condonation of delay. No?
Yes.
Only the delay was condoned.
Yes.
Whether the petition was admitted
Yeah, petition was admitted, delay was condoned.
after condonation of delay,
Yes.
the petition was registered, and then whether you filed any objection there.
No, sir, this order has
No.
been passed. We have filed the objection for the condonation of delay, and this judgment has been passed after hearing both the parties, Your Lordship.
Okay.
Yes. So that's why we are here today, Your Lordship.
Just a minute. Only admission, only admitted.
Yes, only admitted, Lordship. And
Just.
Your Lordship, in the lower court, I have suggested them to file a money suit recovery as well, because like the date is like the condonation of delay is beyond the limitation. I stated that to them, the learned counsel. Your
Just a
Lordship.
minute, just a minute. Your impugn order is at page 21.
yes,
Yes,
page 21, Lordship.
You are aggrieved by the condonation of delay.
Yes, Your Lordship.
This order.
Okay. And in the main petition, you have filed objection.
Yes, in main petition.
Not yet.
Not
Not
yet.
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 Not yet.
Yes.
Yes.
Okay. So according to you, the delay should not have been condoned.
Yes, Your Lordship. Because this is a settled law, that's why, Your Lordship.
So it is not under the discretion of the court, satisfaction of the court.
Yes, like complaint case.
On being sufficient cause being shown.
Yes, but that is for the complaint case. They can file a complaint case if they got delayed, but not for the sending on legal notice. Your Lordship. They have sent a legal notice. That is a settled law, Your Lordship. It is clearly written in the section 138, Your Lordship. There's no
The
proviso.
condonation
Yes.
is a delay on sending the notice.
Yes, Your Lordship.
Okay, where do we find that in the?
No,
order?
sir, Your Lordship, they condemn, a condonation is for the complaint. They did not appreciate the section 138 of the B, the legal notice. During the arguments, that was also there. In our objection, we written that section, that para also, that within the legal notice should be sent within 30 days, but it was not. So that's why the case should be like dismissed. It is not a maintainable. In our IA, we have filed that. But Your Lordship, in our reply, but Your Lordship, the lower court only condoned that complaint case. He did not talk about the section 138, the legal notice, which should be sent within 30 days, Your Lordship. He just condoned it by saying that the under 138, he has a sufficient for the condone to file a complaint, which is 106 days delay. In fact, the judgment he relied is also wrong, Your Lordship.
Okay.
The judgment only talks about the jurisdiction, not about the condonation of delay, Your Lordship. And Your Lordship, in section 138, it clearly stated that the check should be issued for the legally enforceably liability, Your Lordship. Here, all the transaction was between the.
Where in your petition you have stated that you have raised the question of delay in issuing the notice, and that was not appreciated by the trial court.
Your Lordship, it's in 5, page number 7. And in fact, in the page number 7, we have like raised it, Your Lordship. In page number, it's page number 12 and 7,
The complaint case. Yeah.
para 7.
What we'll do
Yes, sure.
is probably because the record
Yes,
I
Your
need to see.
Yes.
We'll fix it for hearing
Okay, Your Lordship.
this matter. The
If it
record,
can, if it can be disposed
record
of
will
today,
have it.
if it can be disposed of today, it's a,
Can be disposed of, but then I need to go through. I
I
haven't
will
gone
be
through.
allowed to make my submission, Lordship.
Hmm?
I will be allowed to make my submission. I will make few things clear, Lordship.
We'll fix it then day after tomorrow.
No,
I need
Your
to,
Lordship,
I need to go through certain things because this NIA case, need to go through, because probably before sending notice, I think delay, if he has not appreciated, not discussed, and probably it will be
That
difficult.
has been discussed, Lordship. That has been discussed.
So the judgment needs to be gone through.
That has
Unless
been
I go
discussed.
through the judgment, it will be difficult. And you are not reading the judgment also. While you are challenging the judgment,
Yes.
you are not
That-
reading the judgment.
That is why,
Assuming that the judge has already read. I haven't read.
Lordship,
yes, yes. Yes. Yes.
that is why I may be allowed to make my submission. Let's start from the
Commission
judgment.
fee, unless we read the judgment, it will be difficult
Let's start from the
from the
judgment.
middle of.
Let's start from the judgment, Lordship.
Then it will take long time. So that is why I'm saying there are other methods also. So that will take a long time.
Lordship. Lordship.
Hmm.
Day after tomorrow.
No, Your Lordship, day after tomorrow, I have a matter in UPR court, Your Lordship. It would be very difficult to reach here. There is a final argument, Your Lordship,
Okay.
in UPR court, Your Lordship. Today also, I have to miss that final arguments for this matter, Your Lordship.
Then,
Any date
because
after.
today, in any case, if there are other matter. If I haven't read the judgment. Try to understand. I've understood a little bit, but then I need to go to whether they have the judgment discussed or not. First of all, when you challenge the judgment,
Yes,
you have to read the
It has to
judgment
be
first.
started.
I haven't gone through.
yes, yes, sure.
Before the vacation, Lordship, tomorrow or
Tomorrow I can't, Your Lordship, and day after tomorrow I have to go Guwahati, Your Lordship. I can't.
Then before the vacation, or we have to tomorrow and day after tomorrow. It will be only after vacation, immediately after vacation. Okay.
Thank you, Your Lordship.
fixed date maybe, Lordship, given.
Can fix, yes.
Any date, yes.
Both. Miss Jang Luju, J. Jang Luju, Land Council for that. No.
No.
Okay, for the petitioner. And Mr. Chape,
या तो नवंबर 1 इसे कभी ले
Land Council for the respondents are present.
सकते
On the request about the Land Council for the parties, let this matter be listed. When?
21st October, Lordship.
21st.
Yes.
Probably there are so many methods. How many methods are being fixed on 21st? Can we?
Yeah, I will.
Okay.
Or 22nd,
23.
Yeah, 23.
23 will.
Okay, we'll fix on 23.
Highly.
Okay.
Lordship.
Item number 7.
Your Honor, Your Honor, that I have to file some new development. I have to file rejoinder, Your Honor, which is very important to place before this honorable court, Your Honor. Because there are two dimensions of the case. One,
You want to file rejoinder?
Your Honor, I have to file rejoinder, Your Honor.
Already filed.
No,
You
yes,
have
no.
to.
Yes, Your Honor.
You are for the petitioner.
Yes, Your Honor.
Item 7.
I am for the,
How much time?
Your Honor, after 3 weeks, Your Honor. More interesting development is there.
Your Lordship, in the case, I've filed my affidavit in opposition,
Okay.
and I've made a prayer with regard to vacating the interim order that was granted earlier.
Your Honor, if
So if the
it-
petitioners
if-
are taking time, then the interim may be vacated because there's no merit in this case.
no, Your Honor, not like that, Your Honor. Very content, very substantial in my case, Your Honor. I have never been in the party of the application before the honorable this lower court, succession application. I have never been party. Despite that, execution has been made against me, Your Honor. And moreover, Your Honor, what?
Okay, execution against you.
Yes, Your
But
Honor.
you were not the party.
Yeah, exactly, Your Honor. Despite my request, only Your Honor, thing is, moreover, the succession application
Okay,
was.
have received the, okay. Okay, so we can give one chance.
Your Honor.
One chance because this probably is the first time after receipt of the affidavit.
Exactly, Your
Okay,
Honor.
Mr.
G. Kato, Your Honor.
Kato, Land Council for the petitioner. Submitted, he has received the affidavit in opposition filed by the respondent and press for some time to file affidavit in reply and press appear in reply. So, please press for comment, let this matter be listed immediately after the entry is the petition. Okay?
Your Lordship, if
Lordship,
it may be
interim may be
fixed on
continued,
27.
On the interim may be continued.
Why did Land Council for the respondent is also present. What?
Your Honor, interim may be continued, Lordship.
Okay, the interim order passed, they shall continue till the next date of this. Okay.
Your Lordship, a fixed date may be given.
Date?
Fixed
When?
date on 27th of
27,
Lordship, on 27, I have a Apopa case already fixed.
26,
20,
26th is a holiday.
26 holiday. Then 28,
Then 22, Your Lordship. 22nd of October.
okay. 23,
Lord.
okay. 23, okay.
Give your
oblige.
Item number 8.
May I please, my lord?
Yes.
My lord, this civil revision petitions file in connection to the impugn order dated 17/2/2025, my lord. My lord, here the gist of the case is that, my lord, petitioners, she has lent some of rupees 11 lakhs to the respondent for purchasing of some plot of land at
A
Duimuk.
minute, sir. The respondent was, the petitioner was to file affidavit in reply.
Yeah, I filed, but
You have filed?
you're fine.
Okay. When did you file? When did you file? You have received? The
My lord,
aff-
yes, there.
Yeah, yeah.
Yes,
We have,
I have
there's plenty
received.
copy also.
Okay,
I have
affidavit
copy
in
received.
reply you have received?
Yes,
Yeah,
yes.
yeah.
Okay. So now,
This was the final hearing today.
it's final hearing,
Matter speaks for admission hearing, my lord.
admission.
Admission itself. Right.
Admit it and we'll fix it for hearing.
Yes,
then
my lord,
But I'm opposing the admission because,
You are opposing that.
yes, Lord, because there's a question of law involved, which is very clear, evident from the statute itself. No judgment required, nothing is required. No external aid is required. Act itself makes it clear that if suit is filed late, delay cannot be controlled. It is the inbuilt provision in the suit, and which is what the learned trial court has followed. There is no if and but in the provision. There is a simple law. If my lord allow me to read
Just a
section 3, my lord,
Just a minute. Sir.
this petition cannot be admitted. There is no proviso, no exception.
So you are challenging the impugn order dated 17 to
17/2/2025.
Yeah.
by this order?
By this order, my lord,
This
the
order.
trial court has
May I
decided.
submit?
Yes, yes, can.
May I submit also?
Yes.
My lord, this petitioner, she was lent some of this 11 lakhs to the respondent for purchasing of some plot of land at Duimuk. So after giving that money, after giving the payment this money, petitioner visited the plot of land, so it was not paid for the settlement. So she was cancelled for the purchase of plot of land from the respondent. So thereafter, she was asked for refund of rupees 11 lakhs, my lord. And accordingly, she was agreed, the respondent, she was agreed to refund of rupees 11 lakhs to the petitioner, my lord. So thereafter, last many occasions, she was failed to refund money. And one occasion, the petitioner went to visit in the house of the respondent. And there was discussion that she will refund the money within short period. But on the next day, respondent has launched FIR against the petitioner before Duimuk police station, and case was registered against the petitioner in Duimuk PS case. It was registered Duimuk PS case number 168 of 2021, and under section 448.
This is one under 115 for revision.
Yes, my lord. So thereafter, my lord, petitioner, she has filed money suit before the Lane Civil Justice Division at the UPA, my lord. It was registered as money suit number 41/24 under section under order 7 rule 2, my lord. She was filed. So when it was filed, also there was a delay of 48 days. 48 days. So she has also filed one application along with the
48 days in filing.
Filing of the delay of suit, my lord.
Filing suit.
So
Filing
thereafter,
suit.
my lord, yes. So she also filed one submission with the cooperating with the Honorable Apex Court Shomoto cognizance, Shomoto writ petitions passed by the Honorable Apex Court during the time of COVID period, my lord.
Filing what suit? Suit for what?
Money suit, my lord.
Money suit.
Money suit of rupees 11 lakhs, my lord, which
Okay.
she has
So
paid
this
to
was
the,
filed after
49.
after lapse of 49 days, as per calculation, my lord. So
no. What is the limitation period? Otherwise,
limitation is, my lord,
3 years.
3 years.
So 3 years 40.
3 years, 49 days, as per date of filing dated 6/8/24, she was filed money suit before the Lane Civil Justice Division, my lord.
This was on, this was during which period?
Money was,
COVID.
money was paid in the year, my lord, on the date.
No, 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 your delay, what was the ground? This was filed on which date?
6/8/24, my lord. 6/8/2024.
24.
Yes, 2024.
There was no. Okay,
Money should was filed on 6/8/2024, my lord.
24.
And transaction was done, yes, my lord. Transaction was, money transaction was done on 18/6/2021, sum of rupees 10 lakhs, and 9/7/2021, sum of rupees 1 lakhs. So it was done in the year of 2021, my lord. So my contentions, my submission is that, my lord, during the time of COVID pandemics, Honorable Supreme Court has passed in writ petition number, show motu writ petition number 3 of 2020, my lord. So Honorable Apex Court has given some limitation period was extended. So because of that, my limitation is extended from
So
15.
you said that you filed only in the year 2024.
Yes, my lord.
There was no corona.
That is there, my lord. So based on that, I have a submission that Honorable Apex Court has passed show motu cognizance in writ petition number 3. My lord, just read out the order, my lord.
Para,
Para
What it
5,
says?
sub para 3, my lord.
what it says?
May I read out?
Hmm.
In case where the limitation would have expired during the period between 15/3/20.
Para 5.
Yes, para 5 of sub para 3, my lord. Roman 3, my lord.
Okay.
Page 4, my lord.
Hmm.
In case where the limitation would have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2020. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. Next para, my lord. It is further clarified that the period from 15/3/2020 till 28/2/2022 shall also stand excluded in computing the period prescribed under section 23 clause 4 and 29A of Arbitration and Conciliation Act 1996, section 12A of Commercial Courts Act 2015, and provisions B and C of section 138 of Negotiable Instrument Act 1881, and any other laws which prescribe periods of limitation for instituting proceedings, outer limits within which the court or tribunal can condone delay and termination of proceedings. My lord, my contention is that this period which already excluded by the Honorable Apex Court, so my limitation has
So according
extended.
to you, this from 15/3/2020
Yes.
to 28/2/2022 is
Yes.
excluded
Yes, my lord.
in your
So
case.
after excluded this period, then my lord, my limitation is extended. Only I have time on till date of filing, my lord. I have 2 years, 5 months, 5 days on. So my limitation is available, my lord. That is my contention, my lord.
There was no delay according to you.
There was no delay, my lord. So,
Wait.
so my lord, there was no delay for filing of my money suit. In
So
fact,
what is the order of the?
my lord, this, Lordship may come to page number 51. Sorry, 52, my lord. Just I'll read out the operative portion, my lord. Page number 53. Page number 53, my lord.
Just a minute. Huh?
Yes. 52, 53, my lord. Annexure C.
Okay. Let us start from 52.
Yes. Applicant,
Yes,
plaintiff is
yes,
represented Learned Counsel N. Kumar, represented respondent, defendant is represented Learned Counsel L. Nara. Instant application has been filed by the applicant under Section 5 of Limitation Act 1963, praying for condonation of delay of 49 days for filing the instant money suit. It is arrived in the application that there was delay of 49 days from 18/6/21 to 6/8/24 till filing of the instant money suit. It is stated herein that the delay was caused unintentionally and was due to repeated assurance made by the respondent. In the written submission filed by the Learned Counsel S.K. Sharma for the respondent, it is stated that the instant application is not maintainable since Section 5 of Limitation Act is granted only in the appellate jurisdiction when appellant miss date of filing, appeal, review and revisions, and that there is no provision for seeking delay condition in original jurisdiction as in the present case. Learned counsel for the applicant rely on judgment of the Honorable Supreme Court in the recognizance for extension of limitation order dated 10/1/22 and submitted the period from 15/3/2022 till 28/2/2022 is excluded, and therefore the instant case comes within the period of limitations. On the other hand, learned counsel for the respondent has, Lordship, next page, submitted that in judgment in para number 2, it is submitted that the exemption granted during the COVID period from 15 March 2022, 28 February 2022, white order dated 23/3/2020 was brought to end white order dated 8/3/21 and was effective only during COVID pandemic. Third, Board of Learned Counsel pursued the application of written submission, also pursued the provision Section 5 of Limitation Act. Section 5 of Limitation Act provides that any appeal or application other than an application under Order 21 of CPC may be admitted after prescribed period if appellant or applicant satisfied the court that he had sufficient cause for not preparing the appeal and making the application within such period. On perusal of the provision of Section 5 of Limitation Act, it is evident that the said provisions applies only to appeal or any application and would not apply to an application filed in connection issued for delay condemnation. Further, on perusal of the judgment referred by the parties, it is seen that the extension of limitation was given during the period of COVID-19 pandemics, and the court has been functioning regularly post pandemic since more than 2.5. In view of the above, prior in the instant application praying for delay condition in filing application money shoot number 41/22 is hereby rejected. This is the order of Learned Civil Judge Senior Division, my lord. So my continuance is that, my lord, since some period has been excluded by the Honorable FX Court in the show more to read petitions. So I have a limitation. I was not need to file a limitations, condone the applications of money shoot, my lord.
But why you have filed?
My lord.
But you have filed.
Yes, my lord. But I have filed money shoot, and then it was found that 49 days is delayed. So I filed IA under Section 5 of Limitation Act. In fact, my lord, Section 5 of Limitation Act is not applicable to money shoot, my lord. It's only for appeal and other application, my lord. That is clear, my lord. So my contention is that application is also not required to file, my lord, because I have available limitations.
But why you have filed? If it was not required to file.
My lord, when we not going through the perusal of the Honorable FX Court order, so we thought that it was a delay of continuation. Record for delay.
There was no delay. You said that there was no delay.
So after going through the, my lord, after going through the Honorable FX Court order, so it was found that there was no delay, my lord. So that was our submission, but that was not considered by the Learned Trial Court, my lord.
Okay.
By civil judgment.
Okay. Yes. What is your submission?
But the same paragraph which my friend was reading from Supreme Court judgment, but only have the same paragraph. Subpara 3 of para 5, which my friend recited before my lord. Para 3, subpara 3. In cases where limitation would have expired during the period of limitation, and my friend's limitation period expired 2 years after that. This is not the person about whom this order was passed. This order was passed for those whose limitation period was expiring during that period. In this case, in the instant case, Lord, the period of limitation expired in June 24. Your period is expiring in June 24. So I fail to understand why you are repeatedly citing this judgment, which was declined by trial court, and again you are reading the same paragraph. You are not covered in this. You are not part of this judgment. Your limitation period expired in 24. Now, this is the generally what we do is when we draft petitions, suits like of the nature which my friend has done, we don't say in the petition that we are beyond limitation. We never ever do that. So now you have admitted that you are 49 days away from that. As my lord was calculating the period of limitation, you have done the task in your chamber and you admitted that. Once you admitted and made this the part of the inbuilt contents of a petition of a suit, then you're out of it. Law bars you. There is a categorical provision in Section 3 that if you are late, you are late. You're out of it. There is no provision for filing Section 5 application
for seeking condonation of limitation in for suit. That reason is only for the appellate jurisdiction. This is what the learned judge has held. So what is the error in the order? Order is legal, valid, and justified. Because this is your case that you are 49 days late. This is your case. This is not my case. The judge has nothing to do with your what you have submitted in the suit. You have submitted in the suit that you are 49 days away, thinking that you will be covered because of the COVID relaxation. COVID relaxation was not applicable in your case. You are caught here.
Yes.
You are caught napping here because you should not have admitted in the first place. So this cannot be admitted.
Met to your lordship.
Yes, sir.
My lord, there is the next item, item 9 possibly, is a revision. My learned friend Mr. S. Sharma has gone there. He can be seen in the screen that he is possibly there for the appellant.
So,
My lord, that on the last occasion, that is on 10th of April 2025, I am appearing for the respondent number 4 and 5 in this case, my lord.
okay.
My lord, notice was issued on 10th of April 2025. Matter is not yet admitted. Today it has come up for admission. May I pray that let it be admitted and a date be fixed for hearing, subject to what my learned friend says.
Yes.
When the matter call lordship, I'll do, lordship will fix. When the matter call lordship.
After two.
All right, all right.
Because I'm here, lordship.
All right.
I'm good for
Met to your lordship.
Yes.
Well, I crave your lordship's indulgence to mention your lordship is already in the midst of the hearing of item 8. In item 9, my lord, we have agreed that on 29th, if the matter is listed, both the sides will complete the hearing, and my learned friend has suggested that we agree that on that it will be taken up for final disposal.
29th of October.
My lord,
sorry.
my
29th of October.
29th of
October.
Okay.
Yeah.
Well, my only point, lordship, is because why I am saying lordship is for final disposal.
Okay.
Though lordship can see the file of the case number 9, it's a voluminous file. If
Yes.
lordship will look, but
Yes.
this is the case.
Okay.
I'll give you lordship this much of document. This is the case, and there is nothing more. So that is why we said that it is better to be disposed of on that day, lordship,
Okay.
because it is not that file, lordship.
Okay.
What happened, lordship, is a student unrest is going on.
Mhm.
It's a student body election.
Yes, yes, sir.
So student body election, there is an interim order from the trial court. Then against the trial court, there is an appeal. There is a high court. All the has disposed of, all has rejected. Then lordship, the deputy commissioner has given an order. Then this SP superintendent of police has given an order against the, even then they are continuing. So that's my point, lordship. Otherwise, my clients are suffering even after getting the order from the court. Out of the blue, lordship, the people violating the court's order. It's a jungle law, lordship, nothing else. That is why I am here, lordship, before a lordship. I am not on here,
We'll
lordship.
argue on 29th.
Initial from the day one, the civil judge junior division has passed the order. They went to the appeal, filed application under order 41, rule 5. It was rejected, dismissed. Against that, the High Court. High Court has dismissed. High Court has said that the civil judge junior division order is correct. He has discussed the prima facie case, balance of convenience, irreparable loss. Now going back, the appellate court said, no, there is no prima facie case. After it's a perverse order, lordship. And this order, lordship, is dragging like anything, lordship. That is why, lordship, let the matter be disposed of on 29. My learned friend has some problem. Okay. So let them come, lordship. I have no problem. On 29, matter may be kept for final disposal, lordship,
Okay, so
on the admission stage.
on the admission stage.
Yes,
Okay,
29th, my lord.
pardon me, sir.
I am S, sir, my lord.
Okay, then what we'll say that we'll, okay, on, board the learned counsel for the petitioner, Mr.
S, sir, my.
Learned senior counsel, assisted by. Okay, Sonar, huh? Is present, and Mr. T. Majumdar, assisted by. Deori,
Tama is there.
learned counsel, respondent are present, staff. On the request of the parties. let-
Not my request,
Okay,
Lordship.
on the
therefore.
request, Mr. B. Majumdar, learned senior counsel, prays for listing this matter on
29th.
29. To which Mr. his name, learned senior counsel, for the petitioner, has no objection, provided the matter is listed on that day for final disposal. Okay.
At admission stage, Lordship.
Okay. In view of the above, let this matter be listed on 29, or on which 29 for admission, huh? On which date the endeavor shall be made to dispose of the entire matter. Okay.
No further
Alright.
adjournment, Lordship. At least that my clients will be protected to that. No further adjournment, Lordship. That may be recorded, Lordship. Every date, Lordship. Only earlier date also, Lordship. The time is going on, Lordship. Already 6
Without
months
any
gone.
further adjournment. Okay.
I am for
Obliged.
respondent number 1.
Okay, you are for respondent number 1. Okay, Mr. Tama, learned counsel for the respondent number 1 is also present.
Oblige.
You are for respondent number 1,
My lord.
and they are for respondent
4 and 5.
2,
4 and 5.
4 and 5.
Ma-
There
But,
is 4 and 5.
senior counsel Majumdar sir is for 4 and 5.
4 and 5. Okay, Tama
My
for
lord.
1, huh? 4 and 5. And who else? Okay. Okay. Soki for respondent number 2 and 6 to 10. Okay.
Oblige.
Highly
Grateful, Lordship.
Oh. आज 20, ये 24 नहीं 29 के लिए था, ये 29 के लिए, ओके 29 को तो नहीं है ना, हाँ ठीक है, ओके यस यस सो
Yes, my lord. My lord,
एनीथिंग एल्स
we'll continue with item 8, my lord.
Hmm?
We'll continue item 8, my lord.
यस
My lord, my prayer and my continuation the based on the FX score show moto order, my lord. Based on para 4, my lord. So here the limitations which excluded
no, so first of all, yours was money suit,
yes, my lord.
okay,
Money transaction was also done in the during the time of COVID pandemic, my lord. So honorable FX court extension the limitation period, my lord.
no, that is, okay, in money suit, for filing money suit,
Yes.
so there is a condemnation petition can be filed under section 5.
Section 5, my lord, that cannot be filed as per provision
why
of
you have
Section
filed?
5
Why
of
you have
Limitation
filed?
Act. So
In the
that-
first place, why you have filed?
because, my lord, it was fine that there was some delay of the delay of 48 days.
Maybe there was a delay.
Yes.
My
So-
query is in the money suit in the money suit, whether the limitation act or application can be filed under section 5 of the limitation act
Yes.
for condonation of delay.
Yes.
Where?
Application, my lord, application, or may I read out the section 5 of Limitation Act, my lord?
Yes.
Extension of prescribed periods in certain cases. Any appeal or any application other than an application under any of the provisions of Order 21 of Code of Civil Procedure 8, 1908 may be admitted after the prescribed period if the appellant or the applicant satisfied the court that he had sufficient cause for not preferring the appeal or making the application within such period, my lord. So, my lord, here in the case is that now the from the side of the respondent, their objection that this is a money suit cannot be filed under Section 5 of Limitation Act.
Yes,
Only
yes.
application and then appeal can be made under Section 5 of Limitation Act. That is their contention, my lord. So, my lord, I'm not.
I have never, because why I'm asking is I have never come across a condemnation petition under Section 5 of Limitation Act was filed. Limitation Act has been filed here. So that is why I'm asking under which provision?
My lord, Section 3, Lord, see, we go through the Section 3, my lord. Bar of limitation, my lord. If there is any bar of limitation, I read out the Section 3, my lord.
Okay.
Limitation Act. Subject to the provision contained in Section 4 to Section 24, inclusive every suit instituted, appeal prepared, and application made after the prescribed period shall be dismissed, although the limitation has not been set up as a defense. For the purpose of this act, a suit is instituted in an ordinary case when the plaintiff is present to the proper officer. In the case of pauper, when his application for leave to sue as a pauper is made, and in case of a claim against a company which is being wound up by the court, when the claimant first sent in his claim to the official liquidity, any claim by way of set-off or a counterclaim shall be treated as a separate suit and shall be deemed to have been instituted in case of set-off or the same date as the suit in which the set-off is pleaded. In case of a counterclaim, on the date on which the counterclaim is made in the court, an application by notice of motion in the High Court is made when the application is presented to the appropriate officer of the court. But after if limitation is completed, so Section 5 is
Where is the limitation prescribed for the money suit, for filing money suit?
if money suit prescribes, Lordship, come to page number.
Limitation period.
Article. Lordship, Article 47. Article number 47. For money paid upon an existing considerations which afterwards pays 3 years. So within the period of 3 years, money suit has to be filed. Money. Of Article 47 of Limitation Act. Money. So here my submission is that, my lord, because my case is not required for filing of limitation, because I have available limitations as per the show motto conditions being writ petition being passed by the Honorable Apex Court. So some period has been excluded. So I'm counting my period from 1/3/22, my lord. 1/3/2022. So
Just one query.
yes.
So he can file limitation, he can file for a condemnation application. According to you, what is your submission? Whether the petition can file
But
an application for
But can I read-
condemnation of delay in filing the money suit?
can I read Section 3 again, my lord? Section 3 of Limitation Act.
Yes.
Subject to the provisions contained in Section 4 and 24, every suit instituted, appeal, preferred, application made shall be dismissed. There is a provision shall be dismissed if it is beyond the period of limitation. And section further mandates this dismissal has to happen even if the limitation is not pleaded, even if limitation has not been taken as a defense. So this is for the judge to mandatorily dismiss it, even if I or any defendant has not taken this plea. Lord, position is very clear. What falls for the consideration, the whole thing, my lord, is what falls for the consideration of this honorable court. For that, my lord, I will take my lord to the impugned order, my lord. Once more, impugned order at page 52, my lord.
So what I've shown to this honorable court, my lord, is that on limitation, my friend is out of the court, because limitation provision is there, which says if suit is filed beyond the period of limitation, it has to be necessarily dismissed, whether opposition, not opposition from other party. This is between the court and the plaintiff.
There is no scope of filing.
No,
That is why I'm asking.
the answer has come from me, my lord. My friend could not give this answer. I have given this answer. That no application, and that's the reason my lord was sharing with us the experience of my lord, that my lord has not come across such case. The reason is very simple, that there is a mandate of section 3. There is a mandate of section 3 that whosoever is the judge, matter is between the judge and the plaintiff. Even if the defendant is absent, not there, ex parte, whatever, the plaintiff has to go. So that is the reason my lord have not come across any such case. Even I have not come across. Even in my career also, this is the first case in which the plaintiff has pleaded condonation of delay in section 5 application, my lord. So on that, my lord, law is very clear. Now, my lord, I will take my lord to the impugned order, if my lord can find time to come at the impugned order, my lord.
Yeah.
If my lord has the impugned order before my lord, it has 3 paragraphs in page 1. My lord, I'm not reading word by word, because my lord have already been apprised of this order. In the morning session, we read this whole order before my lord. But my lord, this order has 3 paragraphs. First paragraph deals with the delay part. Delay is an admitted fact in this case. 49 days delay is there. Judge records this in the order, that there is a 49 delay delay in the case, duly recorded in the order, and this is an admitted fact. So this is not for the consideration of this honorable court. Plaintiff is admitting, I am admitting, judge has recorded it fairly and correctly. I am on, my lord, what is there for the consideration of this honorable court. So, my lord, computation of the period of limitation, how much limitation period is prescribed, whether this is prescribed in Article 47, not, or in some other article, this is not for the consideration of this honorable court. Because delay is an admitted fact. And when this delay is read in conjunction with section 3 of the Act, my friend is out of the court. Now, I move on to second paragraph. Second paragraph, my lord, records whether my friend can file the application of section 5 to seek the condonation of delay. That has been fairly discussed and debated before this honorable court. That was fairly discussed and debated before the trial court. And trial court arrives at a conclusion that section 5 application is not here. In this case, rather no provision is made in Limitation Act to seek the condonation in a case where suit has been filed late even by 1 day, much less for 49 days. So this fact, the whole thing is what wrong the judge has done. Nothing. She has simply fairly recorded, observed, and decided. Observing that section 5 has no application in this case. I am talking para by para to show to this honorable court what can be attacked before this honorable court. So 2 paragraphs go, my lord. Nothing is there for adjudicating and deciding by this honorable court, my lord. Then comes, my lord, third paragraph. Third paragraph talks about the COVID judgment. COVID judgment has also been dealt with at length before this honorable court. It is very categorically stated in the judgment, those whose limitation is expiring during COVID, they may relax and chill. If their limitation is expiring in that period, we are giving you the time from 15th of March to 28th of February as a relaxation period. And you can compute your time, excluding this time, whenever you're going to file the suit or application or appeal, whichever is the case. This is not the case of my friend. My friend's limitation expired in June 24. So his repeated recitation of this paragraph has nothing to do with this case. And so I'm getting back to the impugned judgment again, my lord. In the third paragraph, the judge fairly records this fact. discusses at length in the paragraph which is going on the next page, my lord, and arrives at a conclusion that this judgment has no application. So, my lord, before this, my lord, that's the reason I oppose the admission, my lord, because there is nothing to be admitted or debated post admission. My lord, this petition has to go, because this petition has a question of law involved, and that is a very single question involved, whether he is inside the court or outside the court. Going by the facts which have been laid before the honorable court, my lord, he has no leg to stand before the court because he's out of it by his own admission. His admission is, I'm 49 days late. The minute he says this, he's out. And this has been duly recorded, discussed, debated, and returned in the shape of finding before the honorable court, my lord. If my lord has any query, my lord, I can answer further.
Yes, kindly read section 3 again.
Yes, my lord.
What do you understand about?
Bar of limitation, my lord,
Yes.
subject to the provision contained in section 4
So,
to
read
25.
slowly.
Yes.
Yes, you have me
Subject to provision of contained in section 4 to 24, every suit instituted, appeal prepared, and application made after the prescribed period shall be dismissed.
Dismissed, shall be dismissed.
Shall be
Kindly,
dismissed, although has not been set up as a defense.
Yes,
Yes, my lord, that is there, my lord. That's why
it will be
section,
dismissed. Also.
section 5 is not applicable, although section 5 has been filed. But here in the case, my lord, my content is that as per the show motto, apex court has passed in writ petition. So my limitation start from, as per my counting, 1 March 2022, my lord. 1 March 2020.
And why you had to file this limitation as a condonation petition? You could have filed this, straight away suit.
So that,
Money suit.
my lord, that was during the time of hearing, my lord. I was submitted before the learned civil judge senior division, my lord. So that was not considered. As my learned friend has already read over some portion.
Could have asked them to ask the civil judge, learned civil judge to pass order on that.
So, my lord, that was my condition, my lord.
Is it not?
But I couldn't get it. I couldn't get it.
Your suit was not admitted.
Suit was not admitted, my lord.
Okay.
So that's why, my lord, I have submitted the citations before the learned trial court that I am not need to file condonation, my lord. In fact, because my limitation is available. If we reduce the which honorable apex court has excluded some days, my lord, some years.
Okay.
Can I submit?
So, my lord, clearly it is written in the order of the learned trial court, but she has not considered my submission, my lord, for exclusion of some periods, my lord. So my period is start from, my lord, if we go through the apex court citation judgment, lords, my period is start from 1 March 2020.
It doesn't affect.
So my title suit has to be, my lord, admitted or by the learned civil judge, my lord. So that was my civil, my title suit was, money suit was not been admitted, my lord. So my prayer is, my lord, my title suit has to be restored.
Para 3, learned counsel applicant realize judgment of the Honorable Supreme
Para
Court.
3 and 4, my lord.
Okay.
My lord, can I?
No, just what he is submitting. He says that this was not considered, but see, it was discussed.
No, it is not the case. Lord, can I read the related
No,
portion?
he says that it was not discussed.
It is wrongly stated. And my lord, if I am allowed to speak, Lord, how he can come out of his own admission in his own application, in which he says that he is 49 days late. So what is the fault of the judge? Judge has decided the case based on his own admission in the plaint. It was fairly discussed and considered and decided.
That's my submission, my lord. Since I have already apprised before the learned trial court, but my ground of submission was not being considered. Some period was excluded by the Honorable Apex Court. So that has to be considered, my lord, in my money suit. Supposed to be admit my money suit, but my money suit was not being admitted, my lord.
where the limitation would have expired during the period between so and so. You read this judgment,
Yes.
there are 5, 3 again. For your satisfaction.
3 and 4, my lord. 3 and 4.
3, okay.
3 and 4, my lord.
3, just read again.
Yes. In case,
Slowly.
just I'm reading, my lord, 3, my lord.
3,
Yes. In case where the limitation would have
would have expired
during the period between 15 March 2020 till
Yes.
28 March
Yes,
2020.
yes, pause here.
Yes.
What does it mean?
My lord, this is the past part of the limitation if expire. So that
Would have
limitation,
expired.
some period has been excluded. In para number 4, my lord, some period has been excluded, my lord.
Oh, yes, if limitation would have expired during the period between 15/3/2020 till 28/2/2022.
Yes.
But in your case, the last date falls in the last date. Or failure start from 2024 only.
June 24. Yes, my lord. My money should was filed on 6/8/2024, my lord.
Yes.
Because so just my calculation is that some period has been excluded by the honorable FXO in this judgment, my lord.
So the front part, according to
Yes, so
you, is
I'm starting
excluded.
counting from 1 March, my lord. 1 March 2022. So 1 March 2022, if I
That is
counted,
that
so-
is not that is why I'm asking you.
Yes.
What is the meaning of this? Limitation would have expired during the period. In your case, it expired only after 24 only.
Yes. So I'm starting.
Your
counting
case
from-
doesn't attract.
So limitation condonation was also not attractive if we go through the exclusion part, my lord.
Okay. Okay. Anything?
That's all, my lord.
Okay.
So my prayer, my lord, my money should maybe register, my lord.
Nika and Rama. So this will be discussing with the necessary one. Allowing counsel for the petitioner. I've also heard Mr.
Sushil Sharma.
S.K. Sharma.
SK Sharma, yes.
Okay. Allowing counsel for the respondent number. How many?
Only one.
Only one respondent. For the respondent. Staff, huh? I think I have to reserve this order.
Well, yes.
Hearing concluded. Order reserved. Huh?
Yes. I'm grateful. Deeply obliged.
Matter number 10.
Yes.
May I please to
Yes.
mention this? May I please to may I beg the apparent mistakes might be there in my whole petition.
What
Maybe consider
what mistake?
that the FIR was not annexed in
Okay.
the plan. Maybe consider. So
So you are seeking bail on what? In what case?
POCSO case. This is
This is bail.
yeah, the successive bail application on behalf of Meow
By the way, why the FIR has not been annexed?
that that mistakes I beg to
No, you have to.
that the TRC charge sheet is already here with
Okay,
us.
charge sheet already filed.
Yeah, charge sheet already filed.
Okay, when he was arrested?
He was arrested on 5th of May 2025. And this is subsequent bail under section 483 of Bharatiya Nyaya Sanhita 2023 for grant of bail to Meow Sen Ali, who was in judicial custody since last 40 days. And on charge of section 4 and 6 of POCSO Act 2012, read with section 87 and 64 of Bharatiya Nyaya Sanhita.
What is 87?
My lordship.
87?
Yes, 87 abduction. And 64,
87 or 85?
87. And 64 for rape. Your lordship, may would like
Who
to,
represents the victim?
Your Lordship, I am representing for, on behalf of victim and complainant.
Informant also. So, okay. And then let us see your last bail rejection order.
last bail rejection order,
Who rejected your bail, last bail application?
the special court, special judge. Bail rejection order is in Annexer 4, page number 26 and 27. The reason of Annexer rejection was the before examination of alleged victim, the bail can't be granted.
Now, thereafter, the victim was examined.
Yet not examined after taken cognizance on 19th of May 2025 by the Judicial Magistrate UPA. After that, even after passing of 4 months, till now, no examination was taken up and trial was not proceeded. Your lordship,
Now, if the trial court says that he cannot be granted bail before examination of the victim because victim is a vulnerable witness.
Yeah.
In POCSO case. Then
your lordship, it is against the,
what is your ground?
it is ground, this is
What is your ground to
clearly stated here
justify
in, clearly stated here in section 35 of POCSO Act.
what it says?
After taken cognizance by the magistrate, within 30 days, the trial special court shall examine the alleged victim.
Okay.
It is because of this special provision, the alleged accused is in languaging in judicial
And
process.
if failed to examine within 30 days,
Yes,
so he is entitled to bail.
yes.
Where is that?
Here in section 35 of POCSO Act,
Yes, where it says that if the court fail, he will be released.
evidence of the child shall be recorded within a period of 30 days of the special court taken cognizance of the offense.
Hmm.
A reason for delay, if any, shall be recorded by the special court.
Okay, so must have recorded,
Yes,
the special judge must have recorded. And then where it says that failure to record within 30 days, the
Failure?
accused will be released on bail, where it says.
your lordship, failure to record and follow this special provision,
Hmm.
it is violated the fundamental right under chapter part 3 of the Constitution of India. That right, equality before law is not followed. So, my contention before,
Now the judge says, the trial judge says that if the accused is released at this stage before examination of the witness, her right will be violated. Now whose right is bigger or more important?
your lordship, the keeping behind the bar for such a long period of time is a futile exercise.
Maybe. Okay, yes.
Lordship, I do not have
Any other, anything to submit other than that?
Yes,
What?
that FIR was registered on 23rd of April 2025.
Okay.
Before FIR, MLC report was obtained on 18th of April 2025,
Yes.
which shows the procedural lapse on my case.
Your challenge is also on procedural lapse.
No,
This
I am
application?
only, if bail granted, then any strict of the strictest condition whichever be put forth
Okay.
by this honorable court
Okay,
shall
yes.
be followed.
What is your submission?
I do not have any objection, Your Lordship. If there is any material to which entitle the accused to be released on bail, then I do not have any objection. Firstly, Your Lordship, we are a never. I have not been instructed to raise any object.
Oh, then it becomes more difficult. Yes, yours.
183. In essence, what recorded, that is a statement of but that was acting to 164 of the CRPC.
Yes. Where is that?
It's in page 30 of the petition.
What is the age of the
As per
victim?
as
Okay.
record of the judge, our age 16 years 11 months. Yes, so that certificate is also there. That is certificate. Actually, this petition between had a relationship. Petition had a relationship.
Okay. So who made allegation then?
Allegation, it is made by
Made by her father. Actually, Your Lordship, the alleged accused is very poor, belongs from very poor family. Her mother is a beggar. Her mother is a beggar. His mother is a beggar. Alleged accused mother is a beggar. So, seeing the condition of that
Mother is?
Mother of the alleged accused is a beggar.
Where?
In Laluk, she is a sick person. She can't able to walk properly also. So she is the only son of he is only son of her mother, having 4 elder sisters. Knowing the condition of their dilapidated and 4 condition of that alleged accused, the informant do not want their closeness, want to see the closeness between them. Because of that reason, this FIR come into force. So may I pray Your Lordship may grant him on bail on a humanitarian ground, so that her mother is crying every day to see her son safely again.
You are Mr.
Bat Misi Lomdak,
Hmm?
PM Lomdak, PM Lomdak,
PM
Lomdak.
Lomda, Land Council for the petitioner. I've also heard Mr. G. Taro, Land Additional PP, and Mr.
M. Kamchan,
Land Council appearing on behalf of
respondent number 2.
the informant and the victim, representing the informant and the victim. Staff. Sir. Who filed this bail application?
Shupia Khatun, the elder sister of alleged accused.
Okay.
The age
The-
of
The petitioner is the elder sister of the accused, Mia Hussain Ali. Stop. She filed this application under section 483 of PNSS 2023, praying for release of the accused on bail in connection with Itanagar WPS number 22/2023 under section 87/64 of BNS read section 4/6 of POCSO Act 2012. Stop. Where, oh, you said you have not annexed the FIR.
yes,
See, now where do I find? And it will be very difficult then.
charge sheet, sir.
Where is charge sheet? Oh, recorded. Recorded. Please don't make this mistake. In the bail application, you fail to annex the FIR. Very difficult. What is your expectation from court? That court will consider everything.
Yeah, on humanitarian ground, at least
Humanitarian ground, how can I, where from I can bring FIR, copy of FIR?
I will. May I submit by tomorrow? FIR number 22/2025. WPS.
Do at least complete the minimum requirement for filing application.
I apologize.
Don't you apply your mind before filing application?
That I
Whether bail application was drafted by whom?
myself,
It didn't strike your mind that the FIR is necessary.
Your Lordship, I am new in practice. Exactly. This is my past case. In fact,
You should only remember the FIR
yes.
when you think of filing bail. That is a all might forget, but the new should never forget, because that is a new. That is a first. All people or senior might forget. This is still basic. See, here also FIR. Okay. Where do I find at least the content and then the person who filed? Okay, who is the person who lodged complaint? Chorab Alam?
Saurabh Alam, father of alleged victim.
Yes, father.
Father.
Okay. Para, huh? Para 3. The prosecution case is that on 23/4/2025, one Sri Choharab Alam, father of Miss Anjuma Khatun, filed written FIR before the, which PS?
Itanagar, WPS Itanagar, Women Police Station Itanagar.
Before the OCPS, OC Women in WPS, huh? Women PS Itanagar. Alleging therein that his daughter, aged about 16 years, had gone missing from home on 17/4/2025. No. Alleging that his daughter, aged about 17 years, eloped with a married man. Eloped with the accused, who is a married person. Based on the above written FIR, the aforesaid Women PS Itanagar was registered. After completion of, upon completion of investigation, case was charge sheeted against the accused for offense under section 87 of BNS, read with section 6 of POCSO Act. The charge was from whether that order is also there. A charge was framed against the accused.
32. Turning of the
32 of citizen was framed against the accused.
under 87/64 BNS.
30?
87 slash
No, pay
32.
32
32. Annexure 8.
against the accused. For chart under section
87
okay 87/64 of BNS, read with section 6 of POCSO Act. Stop. What is the age of the no?
Accused.
11 years, for 16 years, 11 months.
16 years. As per the certificate.
Yes,
Yes.
it's per birth certificate. Birth certificate is also annexed here.
Okay.
Alleged accused is also 20 years of age.
This birth certificate was seized by the police.
Yes. Informant submitted before the police.
Para. The Islamic Council for the petitioner submits that The accused was arrested on 5/5/2025, and since then he has been inside the custody for how many days? You said
140 days.
more than 140 days. So it is further submitted that the accused and the victim are appeared in with each other, and the accused had no knowledge about her age. Stop. The record reveals that the victim had stated before the police. Where is the statement of the victim?
Statement
Case 31. It's a statement before court. Statement before court.
Oh,
page 31, annexure 7.
He gave statement before the police as well as before the magistrate under section. What is the new section? 183?
Yes. Before mentioned is
183 BNSS.
This is in case 30.
180,
Page 30.
30.
Yes.
183
183 at page 30.
BNS.
BNS.
It has written, it is written CRPC.
BNSS.
183 BNSS, where she has stated that has she stated her age here?
Yes, he stated that her age is 17 years.
Okay. That she was yes, she was 17 years, and that she went with the accused on her own free will to his to accused father's house at Lakhimpur and stayed there for 2 days, from where she was brought to Laluk by the police. She further stated that she she is talking about another incident, I think.
Uh,
Hmm.
183
Okay.
statement
Mhm.
is silent about physical relationship. It's
Hmm.
only about elopement.
Okay,
running away.
and from police also, just a minute, huh? The police
But
brought me
statement
back
before police.
brought back to Bandadwa, huh? And on 23/3/2025, she again ran away from her house and ran away from her house to the accused, who was accused, ran away and met the accused at Lakhimpur. And it was on her free will to meet the accused and to live with him, where she stayed for 13 days. However, however, in her statement, she is also conscious about the status of the accused, that he was married person. But she still went with the accused since she loved the accused. Stop. The victim has not stated anything about the sexual assault by the accused against her. Stop. The record further reveals that the Thane trial court has rejected the bail prayer of the petitioner on the ground that the victim was yet to examine. Stop. The Thane counsel for the petitioner submits that the accused is the only earning member in the family, and his mother is a beggar at Laluk. Stop. The Thane counsel appearing on behalf of the victim also fairly submitted that he has no objection if the accused is released on bail. He further submits that the accused and the victims are relatives, and
They are not related, they are never.
oh, sorry, neighbor. And then neighbor, although the victim left the house, but she went out with the accused on her own will. And they have no any grievance against the accused, as there is no allegation of commission of any sexual offense against the victim by the accused, as revealed by the victim to the family members of the family. Stop. Para. Mr. Tado, G. Tado, Thane Petition PP. However, you have any objection? Okay, only submit that.
Till now, it has not been agreed.
Okay, although there is, although the victim has stated that she left with the accused at her own will. However, since the matter has been registered under POCSO, registered for offense, for commission of offense under POCSO Act. He has an objection that objection with the, as there is an apprehension that the accused might influence the victim if he had come with victim staff, if he is released on the staff. The Thane counsel for the parties have also considered the records, peruse the records, staff. Upon consideration of the upon perusal of the records and on consideration of the material on records and considering the entirety of the case, and also considering the long period of detention of the accused, this court is of the opinion that the accused can be granted bail. However, the accused can be granted bail with certain condition to ensure his appearance before the court. So accordingly, the accused is directed to be released on bail on execution of a bail bond of rupees 5,000 with one surety of like amount to the satisfaction of the executing court, with further condition that the accused shall appear before the trial court on each date as in each date as in when fixed. Stop. And that he shall not influence, or he shall not directly or indirectly influence the victim or the witnesses of the case in any manner. Stop. With the above, this bail application stands disposed of.
Obliged.
Item number 11.
Your Lordship, item number 11, if Your Lordship remembers, we were discussing on notification number 27, Your Lordship. Notification number 27, Your Lordship. Subsequent bail filed before
Okay, yes, the petitioner is present? No.
petitioner was absent on that day also, Your Lordship.
Then in that case, we can take up now, it appears.
Yes, we can take up, this
Ah,
court can
Then,
take up
but
the
since
matter.
the petitioner is not present, AB was granted to, whether, have you received?
Interim was granted on the
Have you
previous
received
occasion.
whether he thereafter whether he surrendered or he was arrested?
No, Your Lordship, we have, I've just,
What the record says.
we have the accused has appeared, Your Lordship. He has given his statement also, Your Lordship.
Okay, whether he was arrested.
Yes, he was formally arrested, Your Lordship.
Formally
After
arrested.
the interim was granted, Your Lordship.
Okay, then can be made absolute.
Your Lordship, at least will hear the other side, Your
He is
Lordship. In
present.
that, no, the complainant is
Oh, he is
present.
the
Your Lordship.
complainant.
Yes,
Okay, the accused.
their absence may be
petitioner-
recorded and the matter be taken.
Okay.
There.
The petitioner or none appears on behalf of the petitioner when on call. Staff our Miss Jenny Lanet, additional PP, and Mr. Okay, his name,
Agarwal, MK Agarwal, Your Lordship.
Okay. Present, MK Agarwal, Learning Council Learning Council appear on behalf of the informant. Staff.
No, informant himself is being present, Your Lordship. He is not being assisted by any legal counsel.
Okay. Now Agarwal is for.
Agarwal is the complainant, Your Lordship.
Oh,
He is
he himself.
petitioner by.
Oh,
yes.
okay. Then Agarwal, informant, is present. In absence of the petitioner, the matter stand adjourned. This is matter after 2 weeks.
Yes. Deeply.
Lordship, I have a humble
Number
prayer.
12. Yes, after 2 weeks.
Lordship, we will be having vacations then, Lordship.
After vacation only.
Lordship, obliged.
Item number 12.
Your Lordship may, if I may, Your Lordship may also call for the updated case diary, Your
Okay.
Lordship.
On which date? Who will be directed?
I may be directed,
Okay.
Your Lordship.
On which date the Learned Edison PP shall produce updated case diary. Okay.
Deeply.
Lordship.
Yes,
There, please.
yes.
Item 12, my lord. In this case, my lord, CD it was called for. And then along with the CD, my lord, we have also prayed for calling for the records of releasing of those co-accused on TR bond. My lord. Now, my lord, in this case, at least why this applicant deserves, my lord,
a pre-arrest bail, my lord. Kindly come to page 27, my lord.
Yep. Page 27
27, my lord,
of the petition.
of the petition, my lord.
What is that?
Basically, what is the allegation, my lord? Kindly, this may be first taken note of, my lord.
Yes.
Subject is FIR. Sir, madam, with great dismay and agony, I am to inform your good office that my younger sister was missing since 26 July 2025 from village Mecca. And accordingly, we the family members tried our best to trace her out, but got banned. And finally, on dated 28 July 2025, my father lodged a missing report at Santipur police station. And in result, my sister, Miss So-and-so, was brought and dropped back by one lady called Gamno village, Jia, on dated 28 July 2025. Seeing the suspicious circumstances, we the family members seek further inquiry reason behind the missing, and she revealed that she was taken to the rented house of one lady called So-and-so by Sri So-and-so and So-and-so. They seems to be the main accused in this case, which is located at Ibuk village. And on her narration, we the family members came to know that my sister, Miss So-and-so, was engaged in sex racket by Sri So-and-so and So-and-so. That in addition to this, my younger sister denied and refused in indulging in such activities. In response, they threatened her and assaulted her. The reason for delaying in lodging the FIR was that we are not aware of the case. Therefore, on the context, your good office may initiate a legal step and arrest them and book under appropriate section of law for the interest of justice. Next page, my lord. Accordingly, the case by PS case number 51 of 2025 under section 144, 143.3, read together with section 6 of POCSO Act, my lord. It was registered. Thereafter, my lord, may kindly come to page 21, my lord. Why this applicant deserves to be granted pre-arrest bail, my lord. Page 21. While rejecting the first bail application by the learned District and Session Judge, my lord, Teju.
Yes.
There is an observation from the record after perusing the record, my lord. Kindly come to third para, my lord. Page 21. I have perused the CD placed for court's consideration. Prima facie, if material in CD is considered, I am in consonant with the submission of learned counsel for the applicant that prosecutors had attained majority at the time of offense. Meaning, thereby, my lord, POCSO will be not retracted in this case, my lord. Be that as it may, the material in CD suggests that accused applicant so-and-so had taken service from the accused Gegul Gamno and Kapang Gamno, that main accused, wherein despite of the prosecutor's objects, accused Kabuk Lego had joined a physical relationship with the prosecutors. Thus, the offense under so-and-so is prima facie found established against the accused applicant. This is the case, my lord. Even if
the applicant is Kabuk.
Applicant is Kabuk Lego, my lord. He is, I am presently RFO, my lord, Range Forest Officer serving at Rowing, my lord. I have my family and I have no any criminal antecedents whatsoever, my lord. So, in such circumstances, my lord, there is not a case that directly I approach the victim and I have committed the rape, my lord. But in between, there are some persons, my lord. Even if, my lord, my denial is not accepted at this stage, considering on the materials on record, my lord, this is the case.
Whether.
And my lord, my submission, my lord, at least I should be treated at par, my lord, because other similarly situated co-accused, my lord, they appeared before the IO, they were granted, they were released on bail on PR bond, my lord. So therefore, my lord, my humble submission, my lord.
So who was the co-accused?
There are altogether
No, with the,
they are also customer, my lord, seems. As per the information.
what about this? The main accused, one G. Gamno.
Who are named in the FIR. That,
Yeah.
my lord, I don't know about the prosecution.
Lordship, they are under the judicial custody, Lord.
Oh, both of them.
Both of
So, have you seen the co-accused similar with the case of the present applicant has been released on bail,
PR bond, my lord.
PR bond, Lord.
PR bond?
The specification is not there, but then their statement has been recorded,
Hmm.
and there is
They are
no
released.
document as to their release or any court's order, Your Lordship. If that is to be taken, Your Lordship, they might have been released on because their statement has been taken. There is nothing as to their arrest also.
Okay.
Even otherwise, I'll just take Your Lordship. If Your Lordship will see the status report, Your Lordship, that I
Hmm.
have submitted, Your Lordship.
Mhm.
Since Section 6 of the POCSO Act was included in the charge, Your Lordship,
Hmm.
the second page of the status report, Your Lordship will see.
Yes.
Down below, Your Lordship will see there is a serial number 123, Your Lordship.
Yeah.
For thereafter, the paragraph, if I may read, Your Lordship.
Yeah.
So and so suspected to be involved in the sexual exploitation of the victim was apprehended and brought at PS by the previous IO SI Tijama.
Hmm.
However, it was ascertained during the investigation that DOB of the victim is 22/7/2008 as per the birth certificate of the minor victim issued from the registrar, birth and death, Parbuk, Lower Dibang Valley, and she has attended 17 years, 8 days. But the DOB of the victim is 15/6/2007 as per the school admission register of the class 1 standard,
Okay.
which was issued from the headmaster upper primary school, Gia, and she has attended 18 years, 45 days at the time of the registration of the case, Your Lordship.
Hmm.
So even the IO has, there was a birth certificate that was seized, Your Lordship.
Hmm.
Subsequently, since the 94 of the JJB priorly need school registration, Your Lordship, the register of the school was also taken in, seized, Your Lordship,
Okay.
where it was shown that she was 15 years, her date of birth was 15/6/2007, meaning thereby she was already a major when the incident happened, Your Lordship.
Hmm.
Now, if I may take Your Lordship to the next page of the status report, Your Lordship.
Hmm.
Prayer
Prayer.
portion, the last part, Your Lordship will see
Hmm.
that, sir, as per the school record, the victim is major at the time of registration of the case. As such, whatever sexual act after 15 June 2000 is treated to be of her will or consent and does not amount to rape and come under the purview of POCSO Act.
Hmm.
But the only thing that the IO has written is, but during the beginning of 2025, she was minor as per the birth certificate as well as school record. I do not concede with this statement, last statement, Your Lordship. If Your Lordship will see the statement of the victim, Your Lordship,
Hmm.
it was only June 2025, beginning of the June 2025 is when, as per the all the statement of the both the accused as well as the victim, Your Lordship, there was a discussion that they'll be indulging in such activities, Your Lordship. I have also flag marked the statement of both the accused, Your Lordship. There is a orange flag mark in a landscape manner, Your Lordship. Side below.
Yes. This is a statement of
One of the accused, Your Lordship.
accused is 18 years.
No, Your Lordship.
Just a minute. Huh? Victim, sorry, this is victim.
Victims, 183 has also been taken. 180
Yeah.
has also been.
Your Lordship.
Yes.
Lordship, the conducting counsel, he is not keeping well, Lordship. He is going through ill health. As such, my humble
Okay.
prayer, Your Lordship, is that Lordship may kindly be pleased to adjourn the matter
You
for
are
today and
Mr.
fix
You are
another day.
Mr.
M.
You are
Ahmed.
Mr.
M. Ahmed.
Mr. M. Ahmed, Lorry Council.
Lordship, here entry was already been granted and 2 times they have given chance to appear before the IO, but they never appeared also.
Oh, you have a case diary?
Lordship, actually, Lordship, case study, Lordship, updated case we have called for, but instruction was that since he did not appear, so case study we did not call for, Lordship, because only the appearance is required, Lordship, before the IFO statement.
Lordship, the up-to-date case diary may be called for on the next day. And interim may be
But
continued, Lordship.
they never appear, Lordship. Why interim is carry on, Lordship? Because
No, where is the case there? Where it says that he did not appear because he
Lordship,
was directed to appear before the
Yes,
IO
Lordship,
case
I
within
have
5
spoken-
days.
I have spoken to IO via
No, why?
phone,
Where,
Lordship.
where is the record?
Lordship, because he did not appear, that's why case study I could not produce, because that's why they did not send the case study also, because statement, Lordship, need to be required, Lordship. Only
Okay.
last occasion I produced case study, but interim was granted and he was asked to appear before the IO for the state. Last chance may be given, Lordship.
Last chance.
Yes, Lordship, because Lordship, 2 times,
Okay.
Lordship, they did not appear.
Mr. You are Mr.
M. Ahmed.
M. Ahmed. Ghana Council submit that the conducting council has some personal difficulties today, therefore praise for adjournment of the adjournment. Stop. Miss El Hake, Lana additional PP submit that after obtaining interim anticipatory bail, the accused has never appeared before the IO of the case, although he was directed to appear before the IO of the case within five days from the date of the said
Lordship, on this 26th maybe fixed, Lordship.
order. In view of the above, the accused is in view of the above, okay, and as prayed for by the learned PP, let this matter be listed on 26.
Lordship. Okay, evening with
20,
Lordship, may
10,
interim may be vacated,
2025.
Lordship, interim may
which
be
that-
continued, Lordship.
She will produce the updated case diary stuff. Till then, the interim continued. Was it continued?
Yes, Lordship,
Interim
on
was
the
there,
earlier
Lordship.
date.
Okay. So this will be the last chance.
Yes, Lordship.
And then till then, the interim order pass earlier shall continue, shall stand extended. Okay.
Obliged, sir.
Deeply obliged, Lordship.
Item number 14.
Yes.
Item number 14.
Your Lordship, in this case, we had filed our affidavit in opposition. However, on the record, it could not be found, so we filed again today.
Okay. You have received the copy and you want to file affidavit in reply. Okay. Have you received the copy?
Yes.
Okay. Mr.
Yes, Your Honor.
The Learning Council for the petitioner submits that he has received the affidavit in opposition filed by the respondent and pressed for some time to enable him to file affidavit in reply. Prayer allowed. List this matter out after entering entering vacation, puja vacation. Stop. Miss Bhutia, Land Council for the respondent is also present. Okay.
Yep, Your Honor.
Item number 15.
May I please, Your Lordship? Sorry to intervene, Lordship.
Yes.
May I please, Your Lordship?
Next.
Lordship,
What
item
happened?
number. Lordship, sorry to intervene, Lordship. Lordship, 26th, the last date was fixed on 26 October. Item number 13, Lordship.
Yes.
26 October.
Sunday, El Hage will appear. She has suggested 27. 27, make it 27.
Lordship, kindly it may be.
Court
Will-
vacation, Lordship, this 26 is the last date, Lordship. 26 is the last day of the court, Lordship.
Lordship, kindly after puja
26
vacation,
September.
Lordship.
Oh, 26th of September,
Yes, Lordship. Because Lordship, then interim is already.
26th
here,
of
Lordship.
September, not October.
Lordship,
Lordship, the
26
conducting
six-
council, he will not be fit to travel down, Lordship. That is
You
the
appear, it's only, you
problem.
appear. You also don't have to appear. Only you just inform whether the accused has appeared before the police or not. Just inform that. You don't have to submit anything.
Lordship, kindly on
26
8th of October, Lordship.
Okay. Okay, yes,
Sir, steps taken, sir. Steps have to be taken, sir.
okay. Uh, Steps,
Yes.
you have taken steps.
Yes, sir. Yes, Lordship.
Okay. Mr.
J. Bogon.
Lana Council for a petitioner is present. Service upon respondent, sole respondent is still awaited. In view of the above, let this matter be listed after 3 weeks. Okay.
Item number 16.
Your Lordship, Your Lordship, I am appearing on behalf of the petitioners in the present matter. Your Lordship, this is a restoration application seeking recall of the order dated 4th of September 2025 and restoration of the criminal petition number 10 of 2024. Your Lordship, the petitioners have been constrained to file this application because, Your Lordship, the petitioners are the employees
There
of
is
a
private
company.
respondent also.
Yes, Your
There are
Lordship.
private respondent also, it appears.
Yes, Your
Okay.
Lordship,
Will
there are
issue
two
notice?
private respondents.
Yes,
Will
my
issue
lord.
notice?
Yes, issue notice, ma'am.
Okay. Miss,
Your Lordship, if I may be allowed to submit.
we are issuing notice. There are private respondent also. Notice is to be issued.
All
Miss,
right, Your
your good
Lordship,
name?
then a short date may be given in the matter.
Your Lordship, this is Ishita Mishra, the
Okay.
main counsel.
Okay. Lana Council for the applicant.
Your Lordship, I just have just one request, Your Lordship.
By an order dated 4/9/2025, the criminal petition number 10/2024 was dismissed for non-prosecution. Stop. By this application, the petitioner prays for restoration of the criminal petition. And said criminal petition dismissed on 4/9/2025. Stop. Issue notice. Returnable by 4 weeks. Stop. The petition. Sorry. Mr. State is also party. Yes.
Yes, ma'am.
Since Mr. Theatre, landed additional PP appeared and accepted notice on behalf of the state respondent. Number 1, no formal notice is required to be issued. So, however, the petitioner shall take steps upon the private respondent number 2 and 3 by a registered post with AD as well as by usual process within a week from today. Staff. List this matter after 4 weeks.
4 weeks.
Okay.
Much obliged.
Obliged.
Lordship.
Item number
Wait.
17.
Yes.
Lordship, the service is awaited. I may be allowed to take first steps.
Fresh steps.
Yes, Lordship.
In view of the order office note dated 23/9/2025, Mr.
T. Comes, sir.
Lana Council for the appellant prays for allowing him to take fresh steps
Through the
upon
local
the
police
respondent
station.
number 2.
Yes,
Okay.
through the local police station.
Staff, the prayer granted. The petitioner, so the appellant shall take steps upon the respondent number 2 through the concerned police station to be routed through the office of the PP. Okay, stop. Mr. Jenny Lana, additional PP is also present. Stop. List this matter again after
4 weeks.
4 weeks. 3 weeks.
Obvious, Lord. Yes,
How many
so
weeks?
3 weeks.
3 weeks, okay.
Item number 18.
Court record received, madam. Criminal petition, madam. So may be declared for admission, my lord, and interim order may be continued.
Okay,
Yes, ma'am.
agreed, okay. Mr.
S committee.
SK Mary,
I'm not-
Lanet CGS.
I am not appearing as CGC, my lord.
Okay.
From individual capacity, my lord.
Okay, Lanet Council for the petitioner stuff. Mr. El Kurdu, Lanet SC, SIT is also present. The pleadings are completed. The records has also been received since the parties are, and the parties also duly represented. In view of the above, let this matter be listed
My lord, 10th of November, my lord. Because the-
on, in view of the above, and as prayed for by the Rana Council for the petitioner, let this matter be listed on 10th of
November.
November for admission.
Interim order continue, my lord.
The interim order passed earlier shall continue till then.
Item number 19.
Yes.
Your Lordship, step for service of notice upon respondent number 4 has been completed. So kindly this matter may be fixed for admission hearing and may be listed after further
Record not yet received, it appears. Okay. Mr. You are
Yeah, though.
Mr.
I'm appearing on behalf of
Your good name?
Keado
Keado, Lana Council, appear on behalf of
in Tallinn.
N. Tallinn.
Yes.
Lana Council for the petitioner. Miss El Hage, Lana additional PP is also present. The trial court record is still awaited. Trial court record is still awaited. In view of the above, let this matter be listed after 3 weeks.
Item number 21.
Lordship,
Yes,
my lord, this is pertaining to my lord, the criminal division petition, my lord.
okay,
Or civil division petition, my lord.
okay. What is this IFO?
There is a delay of my lord, 270 days, my lord.
Okay.
So it needs condemnation.
Will issue notice?
Yes, my lord.
Okay. Mr. Kishan, Planning Council for the applicant. This is an application filed under Section 5 of the Indian Limitation Act 1963, praying for condonation of delay of 336 days in filing the connected civil revision petition. Staff. Issue notice returnable by 4 weeks. Staff. The petitioner shall take steps upon the respondent by a registered post with AD adherence by usual process within a week from today. Staff. List this matter after 4 weeks.
Much obliged.
Okay.
Item number 23.
Madam, today's matter is fixed for hearing, ma'am.
Okay. Fixed for hearing.
Yes, ma'am.
Okay. Otherwise, both are ready. Okay.
Very,
Can we complete?
I don't think so, Lordship. This is
Not
an
possible. Just a minute. This is conviction for?
My lord, this is, the SIT has, my lord, this state has filed challenge the impugn order, this discharge order, my lord.
Okay. State
Yes.
has filed
Yes.
against the discharge.
Yes. Impugn discharge
This is in
order.
which case?
This is, my lord, Teju PS case, my lord.
Okay.
This is related to mob lynching, my lord.
Related to
Mob lynching, my lord.
mob lynching.
My lord. There in this case, my lord, learned special judge, my lord, has framed the accused person under section under section 147, 140, and 149, but drop charges under section 120B, 452, 353, and 302. So partly, my lord, learned special court has framed charges against the this respondent, the accused person,
Okay,
but partly they have dropped.
okay, you are against the dropping of
Yes, madam.
certain
Certain
offenses
sections. Yes.
against the accused.
Yes, madam.
According to you, that they are the prima facie case.
Yes, madam.
So discharge in respect of the certain offense only.
Yes.
Otherwise, the charge was framed
Charge
against the
is
accused.
framed under some other section,
Okay,
under this one, rioting and unlawful
and
assembly.
which section he was discharged for which offense? What offense?
Charge under section 120B, my lord.
Okay, how many persons were there?
There are, my lord, so many persons were there, my lord.
Okay, but then 120 have been dropped.
Yes, it's been dropped.
120B.
120B has been dropped.
Probably, I think we need to hear it then. So today, but it will be difficult. Or can you finish? No.
I don't think so, Lordship,
Yes, yes.
because
Okay. Both. Okay, Mr. Go to Lanet Special PP SIT and Ms. Nikita Dangelani Counsel for the respondent number.
legal aid counsel for
Oh, sorry,
respondents
Lanet Legal Aid Counsel for the respondent number 2.
1 to 6.
1 to 6 are present. However, due to paucity of time, the matter could not be heard. Accordingly, the matter stand adjourned. List this matter after the ensuing puja vacation. Okay.
26.
Next time after
26, my lord, 26 October, my lord.
26 October.
Yes, my lord.
26 October, probably. How many matters are this?
26
20
October is a Sunday.
Okay, you want on 26. Yeah, okay, we have more time.
Yeah.
27, my lord. Monday.
There will only one case. Yes.
Can it be on 29?
29,
it's-
any case fixed? Okay, 29.
My lord.
Obliged.
Item number 25.
Even in this case, Your Lordship, due to paucity, I don't
Yes,
think-
yes, Mr. Ingo and Mitama is also there. But then,
I am, my lord, LAC in this case.
okay,
For respondent number 4, complaint.
4. It will be difficult.
Yes.
Okay. Mr. Ingo, Lani Counsel for the petitioner. He is present. Ms. Eljini, additional PP for the state, and Mr. Kodatama, Legal Aid Counsel for the respondent number 4 are also present. However, due to paucity of time, the matter stand adjourned to be listed listed after the ensuing puja vacation. Okay.
Item number 26, unlisted motion matter.
Oh, good one. Yes.
My lordship. Lordship, the application is filed by one from whose possession the stolen item has been recovered. Lordship may find the FIR at page number 15. My lordship.
Yes.
Lordship, this is the FIR lodged by the complainant with regards to the missing articles from his home. Considered upon the lodging of FIR, Lordship, the main accused person named herein has been arrested by the Alo police. On
Well, has already been arrested.
yes, Lordship.
Then
No,
you are
no, Lordship, during the arrest, during the interrogation of the alleged accused person, that the name of the present applicant has been revealed by the alleged accused person. Now, Lordship, the breakdown of the case is that, Lordship, the alleged accused person here in the case has frequently visited the house of the applicant herein. There at Namsai, Lordship.
the accused.
No, yes, Lordship. Accused who has been arrested.
My Lordship, while visiting the house of present applicant, she has requested the present applicant to keep one gold chain, allegedly stolen from the informant house. Now, without knowing the fact that the applicant has kept that property in her possession, her custody. However, after knowing the fact that the accused person has stolen that property and given it to the present applicant, the present applicant voluntarily went to the police station and surrendered that article, Lordship. Now, this is the case. Owing to that, Lordship.
No, that was after lodging FIR.
Yes, Lordship.
After lodging FIR.
After lodging FIR and after arrest of the alleged accused person, Lordship.
Hmm.
Now, knowing that the FIR has been lodged and that property article has been allegedly stolen by the alleged accused person, the present applicant, she voluntarily went to the police station Namsai and deposited the article gold chain, Lordship. That is the fact of the case, Lordship. Now, the present applicant has been summoned by the Alo police for interrogation on this 27th of this month, Lordship. This is the only fact of the Lordship case. Now, the present applicant is apprehension that she may be arrested during the time of her appearance before the IO. Lordship, summon is placed at page number 29, Lordship.
Can call for record?
Okay. Yesterday, Lordship.
Okay. Add Mr. K. Ingo, Learned Counsel for the petitioner. Para. By filing this application under section 482 of BNSS 2023, the petitioner seek granting is seeking pre-arrest bail, apprehending her arrest in connection with Alo police station case number 46, 2025 under section 306 BNS 2023. Well, why she deposited ornament now with you?
Lordship, after knowing the fact that
No, before knowing why she deposited that ornament with you, why she kept?
Lordship, on that relevant point of time, the alleged accused person has requested her to keep the
keep in safe custody.
Yes, safe custody, stating that that property is belong to her.
Now what she stated before the police?
Lordship, no, that is not revealed anything in the police, but however, the police has summoned the present applicant to be present before IO on 27th of this month. And the present applicant is ready to cooperate with all possible manner to conclude the investigation in the right direction. Lordship.
It is somehow, just a minute. The case of the petitioner is that 13 Boken Heyo of Rego village, Alo, lodged a complaint regarding theft of gold ornament. Lodged FIR before the OCPS Alo, alleging therein that his mate, his mate or government mate?
His private.
Okay, MATE, huh?
Domestic helper.
Srimati Sushila Tanti has stolen a gold ornament and articles worth around 13 days, 15 lakhs, including gold chain, ring, and other ornaments from his house, and fled fled his residence. Stop. However, his residence and later on seen the accused wearing his stolen gold chain, ring, and other ornament, to which he identified. Stop. Based on the above FIR, a case was registered. The aforesaid case was registered under section 306 B and S. Stop. Para. The land counsel for a petitioner submits that, the present applicant is not connected with the not connected with the above PS case. However, a regular visitor, Srimati Sushila Tanti, who is the alleged accused in the above PS case, once requested the applicant, he or she, requested the applicant to handed over a gold chain
Yes.
to her with a request to keep in her safe custody. Stop. However, after knowing that it was a stolen article, and an FIR in that connection was lodged against her, the petitioner immediately, the applicant immediately went to police station,
Namsai Lordship.
Namsai. The accused is resident of Namsai. Okay, then in that case, the accused, who is the resident of Namsai. Okay. In the beginning, then immediately went to police station at Namsai and handed over the golden chain, stating that it was deposited in her custody by the alleged accused in PS case, in above PS case. Stop. As such, she is innocent. However, innocent in the above PS case. However, since the police has issued, where is the notice?
Notice is page number 27 also. Page number 27.
Notice
Under
under section 35 within bracket 3 of BNSS, requiring her
on 27.
her appearance before the police station, she has a reasonable apprehension that she may be arrested in connection with the above all of PS case number. What was the number?
46 of 25.
46, 2025, under section 306 BNS. Hence this application praying for granting pre-arrest bail. Stop. Para. Call for the, issue notice. Call for the scanned copy of the case diary. Stop. Para. Since Ms. El Hage, learned additional PP appeared and accepted notice on behalf of the state respondent, no formal notice need be issued. Stop. Para. List this matter. Immediately after vacation only.
Lordship. Yes, Lordship.
List this
Because it's
matter.
allo PS, it is quite far. Lordship.
On
Vacation, Lordship, immediately after vacation. Immediately after vacation, Lordship. The 23rd, Lordship, 23 of
on
October.
23rd. Okay. And on 23rd, then stop. In the meantime, comma, in the event of the accused applicant,
Lordship, she has not been made as an accused. Lordship, she has just issued a summon notice.
in the event of the applicant, Srimati Gumnia Kochung, now in the event of arrest of Srimati Gumnia Kochung,
Lordship, in event of her appearance, Lordship,
He may be directed to appear, Lordship, yes, because he's already, this notice been served to appear on 27.
no, she will appear only. The notice given,
yes,
date given,
Lordship,
she is
I'm
bound
ready
to
to
appear.
appear,
But then in the event of her
Yes, Lordship.
arrest,
Yes, sir.
on her appearance,
Yes, Lordship.
her arrest in connection with in connection with the above PS case, above all of PS case number 46, 2025, comma, she shall be released on interim anticipatory bail on furnishing bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the arresting authority, with further condition that she will cooperate and appear before the eye of the case as and when called for, and that she will not directly or indirectly influence or hamper or tamper with the evidence of the case in any manner. Stop. With the above. No,
Lordship, with respectful submission, Lordship, may kindly bail bond of rupees 10,000 may consider, Lordship, since she is a 50
she
year
knew that she cannot have that gold chain, but then she had that one gold chain. She has, see, we can understand. I was about to fix 1 lakh because she knew it very well. You can't say that she didn't know.
Yes, Lordship, that is
You
near,
can't
but
say. She's a mat. House mat.
she is 50-year-old, Lordship, and 3 children.
Maybe, but then 50 years also has a mentality that she has to pay for.
Lordship, may kindly 10,000.
Okay, list this matter. Okay, on 23rd October. Okay.
Apply.
चैम्बर में देखो